Did you just run from me? Sir Cray? Alright, put your hands behind your back. No.
Can I ask you what it is?
Did you run from me?
Body camera video shows South Carolina police take the wrong man into custody after mistaking his license plate for that of a suspect's. Now he's suing the city for civil assault.
He was leaving a Burger King when he was mistaken for someone who was involved in a high-speed chase by the Marion Police Department and was pulled over and subsequently ordered out of his vehicle onto the ground at gunpoint by an officer with the police department and handcuffed, still at gunpoint, obviously giving him a really traumatic experience.
What was the time, lady?
Yay. Grand Rising, we back. Dopest TV, we watching the YNW Melly double murder trial. Murder.
We run the city, we run the town.
So, I don't know what happened here. I don't know. It seemed like they was just talking and then all of a sudden it just disappeared. Like, what the? Got you some coffee, some tea. These text messages, I think is they coming out today or what? Innocent. That's what they say. Biden student loans we have to reject. Okay, Biden. Mm. James Birkin. Ain't there some right here? That's a good ending to that, hopefully. Alright, y'all. We waiting for court to resume. Tonight we back, brother. Grand Rising, Grand Rising. He said he been looking at details over the weekend. That's right, tonight. Hey, real talk though. You said you've been catching up on these details, huh?
Welcome back. I'm Anjanette Levy. Thanks for being with us on this Monday afternoon. We are awaiting the start of the YNW Melly murder trial. It will start very soon, within minutes, we hope. And the lead detective in the case, Detective Mark Moretti, will be back on the stand wrapping up his direct examination. He's been going through text messages between YNW Melly and Sack Chaser, who is Anthony Williams, one of his good friends. Also going through some text messages with his mother, Jamie. Law and Crime's Terry Austin is down at the Broward County Courthouse in Florida, where the trial has been underway for weeks. She's been covering it since the very beginning, and she joins us now to bring us up to speed. Good morning, Terry. Let me know a little bit about what you expect from today.
Well, I'm expecting Mark Moretti to finish his testimony on direct. We had a long break because one of the attorneys on the defense team was ill, and so the judge broke early on Wednesday, and we had Thursday and Friday off. So I expect that they will be prepared to finish up this testimony. Some of it has been very tedious, and the jury is basically trying to focus on what is going on as the text messages and the Instagram messages are read back and forth in this trial. Some of it has been interesting, I will say. Some of it has just been a little bit boring, frankly, but they are showing some disputes between Melly and his mother, and they are showing some conversations between, as you mentioned, Melly and Juvie. And so it's just very interesting. And Sack Chaser, basically, they're going through all of the messages. So I think today they're going to finish up. He is, remember, the expert on Cell Hawk and Celebrate, and he's saying that, you know, he extracted all of this, he analyzed all of this data, and so the prosecution wants the jury to hear what these conversations were. We also saw, if you recall, there was a documentary that was shown, and it was a Melly documentary, and it was showing that the relationship between Melly, Sack Chaser, and Juvie, and it was very interesting. They had a very close and intimate relationship. They showed them in the studio while they were working together. And then at the very end of that, they showed that the memorial basically to Sack Chaser and to Juvie at the end saying, look, shortly after this was taken, they were shot, and they were the targets. They were all the targets of a shooting. So I think it was a touching end. It was something that the prosecution wanted to put in, but frankly, based on what I saw, it looked as though it could very well help the defense. So I think the defense is ready as far as they're concerned for the cross-examination. They've had some extra time now, and I do expect, even though Moretti has been on the stand for 2.5 days, I do expect that they will conclude this morning. We heard Christine Bradley say 2 hours, so I expect that by this afternoon we'll probably see the cross-examination of Detective Moretti.
And then I would expect, Terry, the defense case to start in the morning. I don't know if they would start this afternoon. That cross could take a long time. This is somebody that the defense took aim at in their opening statement. They took aim at Detective Moretti, basically saying this investigation was botched, he wanted to be a star, things like that. Really, it looks like the prosecution is putting all of this in because they're saying, look, here's the tension that was going on in the months leading up to the murders. We believe this shows potential motive. There's discussion about money, about who's getting credit. Sack Chaser and Jamie are basically not in agreement. There's something going on between those two. There's some kind of, beef between them. So that is kind of interesting, something we're hearing about as his testimony continues.
Well, that's right. And they also are talking about a dispute between the two of them as far as a girl is concerned. And I do think the prosecution is trying to show that it wasn't all, fun and games, and it wasn't all positive, that there was some acrimony between the parties, although, based on what I've seen so far, nothing as far as a motive for murder is concerned. They grew up together. I'm sure there were probably multiple disputes between the parties. At some point in time, there was not a smoking gun there. I mean, there were messages that talked about some, dispute that they had over money and some dispute that they were having about a woman. But to my, opinion, I don't think it was anything that the jury might have looked at as to say, okay, well, this is a reason why, this is the motive why on this day he would get up and say, look, after I finish recording in the studio, I'm going to go out and shoot up my closest friends all my life. It's something the prosecution needs to establish just from a, perspective of the jury. Obviously, they don't need to establish motive from a legal perspective, but I do think that jury is waiting to hear and to understand why this occurred.
It'll be interesting to see how the state ties it together in closing, which I think what will happen, they'll kind of connect their dots then, which we often see in these circumstantial evidence cases. And it'll also be interesting to see what the defense presents when they call their witnesses. We know they're planning to call some civilians and some experts. So, Terry Austin, we're going to let you go, let you get into court, and we will see you later today. Thanks for coming on.
Thanks, Anjanette.
All right, we have some other news to tell you about today, and this just kind of broke last night. You know the Mallory Beach case, the boat case in which Mallory Beach, a 19-year-old girl, was on a boat driven by Paul Murdaugh back in February of 2019. Paul Murdaugh, of course, now the late son of Alec Murdaugh, who was convicted earlier this year of killing both Paul and Paul's mother, Maggie, Alec Murdaugh's wife. The boat case and the boat crash that killed Mallory Beach has been looked at as something that really was the impetus or set in motion a chain of events that led to the murders of Paul and Maggie Murdaugh. The boat case, the civil case against Parker's Kitchen and Alec Murdaugh, was scheduled to go to trial in August. It was going to start on August 14th. It was going to be a civil trial, suing for damages, the Beach family was, and the other people on the boat, because they said that Paul Murdaugh had purchased alcohol illegally, underage, from Parker's Kitchen, and had then driven the boat and crashed it and killed Mallory Beach and injured the other people on board. Well, there was a mediation session on Sunday, and this lasted all day long between all of the parties. And we found out last night that the case has now been settled. Insurance carriers for Parker's Kitchen, the convenience store chain, will pay Mallory Beach's family $15 million to settle their portion of the case. Alec Murdaugh's all of his assets, anything he has left, are in a receivership. So he has also settled his portion of this case. And so any money in that receivership will likely go to the Beach family. I talked to Mark Tinsley, who you remember, if you watched the trial, testified at the trial about the boat case and how stressful it was for Alec Murdaugh since he was suing Alec Murdaugh. And he said that the Beach family hopes that this number, this $15 million number, will be something that shows people who are in charge of alcohol, hey, you have to take this seriously. You'll recall that Paul Murdaugh had used Buster Murdaugh, his older brother's ID, to go into Parker's and purchase that alcohol. We later saw a surveillance video of him at Luther's, a bar in which he and his friends were drinking. They were, doing shots, things like that. They then kind of walked down a promenade of sorts on the water toward the boat. They get on the boat, and sadly, the crash happens a short time later. Mallory Beach, on the boat with her boyfriend and everybody else. Her boyfriend, Connor Cook, has explained in documentaries and things like that, and he's recounted how he was holding on to Mallory because the boat was going so fast and they wanted Paul Murdaugh to slow down. And he has described how she essentially flew out of his arms and into the water. Mallory's body was missing for a very long time, days, and they finally found her many days later downstream. So it's been a really horribly sad case. It's a tragedy on many levels because of the loss of Mallory, but also because of what happened later on with the homicides. Alec Murdaugh, of course, claims that he is still innocent, but he was convicted earlier this year of murdering Paul and Maggie. And really, the prosecution in that case said The boat case kind of unraveled Alec Murdaugh's life because he was being forced to produce records that showed the state of his financial house, the condition of his finances at the time, and that he was going to be exposed for stealing millions of dollars from his clients and his law firm. So an interesting turn of events there. We're still working to get some details on how much money the other people on the boat are going to be getting. They will be compensated as well, and they have other lawyers, not Mark Tinsley. There's also another case having to do with the Beach family. It's a civil conspiracy case in which the Beach family are suing Parker's Kitchen and Greg Parker, the owner of that chain, because they're saying they leaked and published photos of Mallory's body after she was dead and some other things. So it's not over, but the boat case is over. The civil conspiracy case still ongoing. So we just wanted to bring you up to speed on that. Insurance carriers for Parker's Kitchen are going to pay the Beach family $15 million to settle this lawsuit. Big news there. So we're going to take a quick break. When we come back, we'll be getting into the Melly trial. Stay with us. I'm Anjanette Levy, and you are watching Law and Crime.
You are watching Law and okay. I don't know. I did watch that Murdaugh. I don't know if y'all ever seen that documentary on Netflix. It's a good documentary. It's crazy. It's crazy what you do when you got money. It's crazy what you do when you don't have money.
President, defendants, and his counsel, the assistant state attorneys, the juries in the jury room. I think everybody's here now, but can I see the attorney sign more, please? Oh, Miss Liberty, how do you feel? Are you all right?
I'm great, thanks, Judge.
I had a query for
Irritated already, don't it? They ain't even started.
Ms. Bradley?
Yeah, that's it.
The note? There's one for defendant, this counsel, the assistant state attorneys, and one of our jurors was saying, I got your message, your note, and I shared it with the attorneys. I don't quite understand. I guess, are you indicating this is a financial hardship to you? It said you're at work, but you're truly needed there, but it says your pay is short by a substantial number. And so I don't know if you're telling us it's a financial hardship on you to continue, or what you really mean by the message.
Well, I really sacrificed it in the beginning, but since I was calling to be questioned without the internet and all that, I'm like, no, I'm just done with it.
Well, nobody tries to embarrass anybody, and I know you wrote in here about trying to be embarrassed. We're not. It's just something came up, and we just inquire the jurors what's going on, if there's an issue or not an issue. And so the question in this message is you're suggesting that on one end you want to be the alternate, so I would like to be an alternate, and then it goes on and says that your pay is short, and it seems like it's causing you a financial hardship. So
it hasn't caused me a hardship, but like I said, since I feel like I'm really not needed here anyway, since I was questioned, just get to go back to work. And I mean, if I have to sit and then be an alternate, I just choose to be an alternate. I want to do my duty, but since I was questioned, like I was doing something wrong.
Let me stop. No. That's when we get when issue comes up, we just talk to jurors, and you're under oath, and we trust that you're giving us a truthful answer. You gave us an answer, and we move on. That's all. They're just trying to put on the record. Whenever there's an issue that comes up, we ask the jurors and talk to the jurors about it. Nobody's trying to embarrass anybody. Nobody's trying to, in any way, shape, or form, do that. The only issue is there's procedures in place, and when an issue comes up, I need to inquire. That's my job. I have to inquire. I'm not trying to embarrass anybody. So you're telling me it's not a financial hardship. You want to do your duty. Is that correct?
Yes, but until, because I know you have to take off 2 alternates, right? And I just want to be on that.
Thank you, ma'am. I appreciate it. I'm just trying to find out what the true intent of the message was. Thank you. Thank you. Let the record reflect the jurors step down. Counsel remain along with the defendant. So, counsel, you ready to proceed?
Yes, sir.
Want to take any action at this time?
No, sir.
Nope. State? Nope. All right, so we're all set, ready to go?
Yes.
All right, bring jury in. Where's the witness?
I have to go get him, Judge. He's in.
Let's get the witness first, though.
Still using the rest. Oh, right.
You're entering?
Yes.
Ladies and gentlemen, good morning. You can see hope you have a pleasant weekend. In any event, we're back on regarding you can see it. Thank you. Let the record reflect the presence of Mr. Dennis, his counsel, the assistant state attorneys, ladies and gentlemen, our attorney. As I was saying, ladies and gentlemen, I trust you had a nice weekend. I think we're all ready to proceed. Is Detective Moretti out there? Yes, sir. Could you bring him in, please? Good morning, sir.
Good morning, Alan.
Detective, as I'm sure you're well aware, we placed you on the road last week, right?
Yes, Your Honor.
And I want to let you know you're still in your direct examination, but you remain under oath. Understood?
Yes, Your Honor.
Thank you. Madam, if you're ready, you may continue with your direct examination.
Okay, Detective Moretti, we were in the middle of publishing the state's last numbered exhibit, which was 117. 117. So on the first page, which is actually page 71,473 for counsel, then we were discussing the user and the messages between YNW Melly Instagram and JKingRN.
Excuse me, Ms. Bradley, the monitor's not working here.
Oh, let me turn that on. Thank you.
Turn it on and off.
Well, it might be a little inconvenient, but if we could, perhaps we could just use this screen here.
Yes, ma'am.
So Detective Moretti, if you could publish the text of October 24th, 2018, 5:01:23 UTC from the user JKing. All right.
That the text was, Jamell Demons, go lay down, I love you, all in capitals.
And remember, demons like rhymes with lemons. I know. Okay, going on to October 26th, 2018. Publishing the next message here, and this is 10:58:02 UTC. If you could remind us again the math calculation on October 26th of 2018 to get from UTC time to local Eastern time.
You just subtract 4 hours from what you see at UTC, and that gets you into the Eastern Standard Time.
Okay, and so who was the author of this message and who was it sent to?
The author was J.KingRN, and it was sent to YNW Melly.
And what was the content of that message?
Are you okay? Question mark. I'm here in Miami. Send me an address. I'm by the stadium. I'm a mess.
Okay. So staying on that same thread ID, October 26th, 2018, and for Defense Counsel, that's page 75,935. The next message of October 26, 2018, 11:26:16 UTC. What is the message?
I'm so worried. I'm here. Do you want me to come to your house?
And going to the next message, the response, and who is that from?
It is from the account of YNW Melly, and it is to J.King RN.
Okay, and what is the content of that message?
I'm good, Ma.
Continuing down, the next message in that thread, October 26, 2018, 11:26:31 UTC. Who is the author?
The author is J.King RN.
And what is the text of the message?
I love you.
And who is it sent to?
YNW Melly.
Continuing on page 75,936 for Defense Counsel. And at the top of the page, the message of October 26, 2018, 11:26:38 UTC.
The message is, love you too.
And who is that from?
YNW Melly to J.King RN.
So the response message, October 26, 2018, 11:26:58 UTC. What does the message say?
I need to find a hospital near you.
And who is that going to?
J.King RN is the author and recipient is YNW Melly.
Okay. The response from YNW Melly, 10/26/2018, 11:35:59 UTC.
The message is, I don't want to go.
So Detective Marty, I want to take a break from the Instagram for a second. We'll come back to that one. During the course of the investigation, did you author a number of search warrants?
Yes, ma'am.
Approximately how many search warrants do you think you authored?
Well over 40, ma'am.
Okay. Did those include search warrants for the Instagram social media of Cortland Henry?
Yes, ma'am.
Approximately how many of those were done for Cortland Henry?
We did one for Cortland Henry's Instagram account, one for his Gmail account, and one for a phone number associated with him.
Were there any indications in those social media accounts or anything else that he was using the YNW Melly account?
No, ma'am, none whatsoever.
Were there any indications that Mr. Henry or anyone else was saying contact or talking about any indications of using the 9807 phone number?
No, ma'am.
We talked briefly about some of the financials when we were on the stand a couple of days ago. During the course of this investigation, did you author subpoenas to get all of those financial records?
Yes, ma'am.
In the total amount of money and the time frame, if you could explain how much money was coming into these accounts?
The total coming in, and I done the subpoena started from I think right around March to for the Sun Trust, which is Truist now, so it'd be March, April, May.
Do we have the account number or name? Thank you.
So Detective Marty, in terms of you're talking about the Sun Trust account.
Yes, the Sun Trust account was in the name, I don't know the last four of the account number, but the account was in the name of Jameson Francois.
Okay. I'm sorry.
Jameson Francois.
And in terms of the business account for Jameson Francois, were some of the beneficiary or payouts of that to Jamell Bevins?
Yes, ma'am.
The total amount of money that went in to the Sun Trust account as well as the Chase account,
Yes, ma'am.
about how much money went in?
Total amount for those two accounts for a 30-month period was about $16 million.
How much?
16 million.
16?
16.
Thank you.
Okay. Detective Murray, in terms of the swabs that were put into evidence previously from the Jeep, do you know on what date the swab of the interior passenger door for the rear driver's side, do you know what date that was collected on?
10/26/2018.
So you discussed briefly as well about looking at the car on October 26th of 2018 about there being damage to the car. Do you recall that?
Yes, ma'am.
You would, and I'd asked you the next question as to, do you recall if there was a discussion as to how the car had been damaged previously?
Yes, ma'am.
Have you had the opportunity to review the statement since that you took a Portland hearing?
Yes, ma'am.
Do you now recall where that damage to the front hood supposedly occurred?
Yes, ma'am.
And where was that?
In Atlanta, Georgia.
In terms of the statements or anything about the damage to the tires or the rims, did you ask the defendant, Mr. Henry, about that, those tires or rim damage in that statement? And if you don't recall...
Yeah, I don't recall this time.
So I'm going to, with looking at a copy of that statement, refresh your record.
Yes, ma'am.
Okay. So looking in for defense counsel, page 6 of 13 of the transcript statement. And it's going to be this thing is right there. Just read that silently to yourself. Okay, Detective Marty, did Mr. Henry describe some sort of incident in which the Jeep ran into a median?
Yes, ma'am. According to his statement, is when the alleged drive-by occurred, he swerved and hit the median.
Okay, and did you notice any damage or anything consistent with that on that Jeep?
No, ma'am.
So you mentioned you've done on a Facebook account on that. And so I'm now going to be showing what's been previously shown to defense counsel and marked as states in tuple R. At this point, the state would offer states in tuple R pursuant to 90.803 sub 6 as a business record.
Any objection?
Objections on grounds previously raised.
It's over, it'll be admitted.
Okay. So Detective Marty, we discussed the Facebook account on that. Was there a cell phone number that was associated with the Jamell Demons Facebook account?
Yes, ma'am.
And what was that?
772-713-9807.
Okay. Publishing page 1. Detective Moretti, could you explain the line where it says date range?
The date range is where when we author the warrants, that's the date range to where we're requesting that the provider, which is Facebook, all of the data they have during that time frame.
Okay. And so what is the time frame that was covered under this particular search warrant?
10/1/2018 to 1/18/2019.
Okay. And what was the name of the account?
Jamell.Demons.
Demons, right?
Demons, my apologies.
Okay. In terms of the email addresses that are on there, on that account, are those some of the email addresses that we talked about previously?
Yes, ma'am.
Okay. On the registration date, September 19th, 2010, what is that?
That's the date that the account was created with Facebook.
Now the next thing is part of page 1 is listed as mobile devices. What are the mobile devices portion of the Facebook returns?
That's all the mobile devices that are connecting to the account.
And does this go back until the creation date?
It goes back to the date to where we authored the warrant.
So in terms of does some of this information go from the beginning of the account itself?
Yes, ma'am.
Okay. And the phone number you mentioned on there, and this is now on page 4. What phone number was verified on this account?
772-713-9807.
And going to the PayPal account, what was the email for the PayPal account that was associated with this Facebook account?
mellymontana@icloud.com.
And if you recall, what was the name of the Snapchat account that was previously introduced into evidence as State 7?
Melly Montana.
In terms of the IP logins, did you do any additional research on these particular IPs?
No, ma'am.
No. During the course of the investigation, did you have the opportunity to review all of the messages and content on Facebook?
Yes, ma'am.
Was there ever any indication somebody else was using that account?
No, ma'am.
In terms of the location, Pembroke Road and US 27 on the south side of the street, what jurisdiction is that in?
City of Miramar.
What county?
Broward County.
What state?
Florida.
And in terms of the individual that you've been identifying as Jamell Demons, do you see him in court today?
Yes, I do, ma'am.
And how do you recognize him?
He's wearing a black jacket, white shirt, sitting next to Mr. Addison.
Okay, and the records will reflect the in-court identification of the defendant?
Yes, counsel. We'll reflect the in-court identification of the defendant.
Okay. So I want to go on to the last Instagram message thread that we'll talk about in this case. It's been previously shown to defense counsel as states quintuple S, and a copy provided thereof. Detective Marty, do you recognize states quintuple S?
Yes, ma'am.
How do you recognize that?
Is the Excel spreadsheet I created. I was able to isolate the thread ID and put it into a more readable format, because sometimes it's difficult reading it from the several thousand Facebook, Instagram pages. So I put it into a format on Excel, and you could easily read through and see the to and froms.
Okay. Does that fairly and accurately depict the thread ID between an individual identified as PZ_Bambino and the YNW Melly Instagram account?
Yes, ma'am.
And is that the thread ID ending in 99651?
Yes, ma'am.
Is it any additions or deletions from the thread ID from the Instagram business records?
No, ma'am.
Now, at this time, the state would request to move states quintuple S in as states 119.
And we approach.
Yes.
There you go. Sidebar marathons. Sidebar marathon. Man, how much stuff was actually in this phone? Like, we done went through 5 billion text messages, phone calls. How many pictures was that one day? Like 400 pictures, videos. Man, that boy had extra gigabytes of storage, didn't he? Make sure I hit that subscription button for me. Hit the thumbs up, man. Keep us popping. I appreciate y'all tuning
Next
in
number.
this morning.
112 S will be marked
Dopest
stage
TV.
119.
So Detective already, so it's clear on this page 1 and page 2, they go together.
Yes, ma'am.
And you did the calculations or adjustments for Eastern Standard from UTC in this particular document.
Yes, ma'am.
So in terms of, without saying specifically what, was Mr. Gambino offering merchandise to be sold to the YNW Melly?
Yes, ma'am.
Was it real estate?
No, ma'am.
Were they physical, tangible items?
Yes, ma'am.
So going forward to the dates and times in question, when you're going through on this, I want to make sure it's clear that this first line corresponds to the page numbers. And where are you getting those page numbers from when you generated this document?
Top right-hand corner of the records provided to us from Facebook.
And this particular conversation, were you able to go through and isolate all of the information on this thread ID?
Yes, ma'am.
So with your permission, I'm going to go through, if we can just, if it says sender PZ Gambino, I will read it aloud, and if you would respond with whenever the sender is YNW Melly.
Okay.
So, first message, 10/19/2018, 1906, sends a photograph from PZ Gambino.
Then 10/19/2018 at 1907, a message from the account of YNW Melly to PZ Gambino, tell him 450.
10/19/2018, 1911, PZ Gambino, he say 5.
10/19/2018 at 1911, YNW Melly, 475.
10/19/2018, 1929, PZ Gambino, say less.
10/19/2018 at 1932, YNW Melly, 480 at the most. 10/19/2018 at 1938, YNW Melly, what'd he say?
10/19/2018, 1953, 480, call that number when you ready.
10/19/2018 at 1959, YNW Melly, bet. 10/19/2018, 2024, YNW Melly, yo.
10/19/2018, 2029, PZ Gambino, yo.
10/19/2018 at 2032, YNW Melly. Might have to Uber, y'all. 10/19/2018, 2033, YNW Melly. To my crib and Uber y'all back.
I'm going to fast forward now in terms of the timeline and go to October 25th of 2018. Going to specifically 10/25/2018, 1436. PZ Gambino, you got a old iPhone you don't use. 10/25/2018, 1442. PZ Gambino sends a photograph.
10/25/2018 at 1540, YNW Melly. Hell no.
10/25/2018, 1542. PZ Gambino, damn, all right.
10/25/2018 at 1543, YNW Melly. You need one?
10/25/2018, 1543. PZ Gambino, hell yeah, dog, I need a phone ASAP. Okay.
10/25/2018, 1940, YNW Melly. The response is an unidentified emoji.
10/25/2018, 1940, PC Gambino, YNW Melly, unidentified emoji. So when it says unidentified emoji, how are you able to translate that or see what those are?
It's usually little tiny like rectangles or little squares that identifies its emoji, but when we try to put it into a Word document or something to translate it to see what it is, we can't read it.
Okay. Do some of them translate in a Word document?
Some do, some don't.
Okay. So going to October 26th of 2018, not this specific conversation, but in reviewing the totality of the Instagram messages, are people checking in with the defendants or the YNW Melly account?
Sustained.
Are individuals sending messages to the YNW Melly account?
Yes, ma'am.
In terms of, are there responses to each of those messages from the YNW Melly account?
Sometimes, yes, ma'am.
In terms of images and photographs that were still circulating on social media on October 26th of 2018, were they all fair, accurate, and true statements as to what happened?
Sustained.
In terms of the October 26, 2018 Facebook messages and social media information about these shootings that had happened.
There was a lot of false images.
Sustained.
Move to strike on curative instruction.
Jury district.
If we could approach?
Sure.
Sideboard marathons. Sideboard marathons. I hate when they just going through all these little messages like this. Like, none of those messages seem like they got anything to do with anything. I'm waiting to get to the juicy messages. Like the one where she said that he said, shh, I did that. I still ain't seen that message, y'all. He said, shh, I did that. Hold on, let me hit y'all with the shh. I don't know. This is just like, lady, just cut to the chase. Cut to the chase.
Detective Moretti, was there a video of a white Jeep that was circulated on October 26th of 2018?
Yes, ma'am.
Was there a white Jeep involved in this in any way, shape, or form?
No, ma'am.
When you are going through the messages, you mentioned that the defendant did respond to some of them.
Yes, ma'am.
But I'm going to go and pull up page 75,932. So, Detective Moretti, I want to continue in that same thread with Mr. Gambino, Easy Gambino, that particular message. And I want to go to specifically October 26th, 2018, 1940 UTC. Or, I'm sorry. Ten 26, 2018.
Uh-oh.
You mentioned you can copy and paste them into Word to as such. On October 26th of 2018, at 20:02:18 UTC. What does the YNW Melly account state?
I did that with a smiley emoji.
In terms of what was that in response to from the PZ Gambino account?
Objection. Overruled.
The PZ Gambino account asked him if he was okay, and his response was, I did that, and placed a smiley face emoji.
And the next message from 10/26/2018 at 16:02 from Eastern Standard Time, the YNW Melly account says what?
After that, SHHHH.
And could you please stand and point on the right side of the screen exactly which part you're saying where the YNW Melly account says, I did that?
I did that. This is the thread ID. This is the text. This is the author. And this is the recipient. They come down here, same thing. The ID is for the actual message, which is just specific that one message. Then the thread ID is the actual continuing message. And they come down here to it says text. The SHHHH.
No further questions, Your Honor.
Keep that up, will you please?
Of course.
Lead Detective Moretti. You are the lead detective, right?
Yes, Your Honor. Yes.
Well, you just promoted me, so you better apologize to the judge.
Sorry, Your Honor.
I'd like to consider it. I can't see my eyes. Could you point to where I did that? Is that correct?
Yes, sir.
And how do you spell that?
THAT.
Okay. Let me show you some copies of 9807, please, without going through all the messages. They're all from exhibits that you introduced. May I mark this as a composite exhibit? Please. Do you have any objection?
Counsel, are you offering it?
I'm going to offer it in evidence, yes. As a composite
Are you doing it
exhibit.
now?
Huh?
Are you doing it now? That's what I'm trying to find out.
Yes.
Have you stated any objection?
Starting evidence, if you just would cross-reference from which exhibit you got these from.
I wish I could. There's 4,000 of them that we took samples.
Excuse me one second. So it's admitted. What's the next exhibit number?
Be pre-marked as defense exhibit D.
It's going to be offered in evidence. So
And offered in evidence as defense 4.
in evidence as defense 4. I'm sorry.
Defense 2.
Defense 2. I'm sorry.
Pre-marked as defense 2.
And how many pages?
I didn't count.
I'm just asking the clerk to do it.
I apologize.
No problem.
I get past, when they mention 70,000, I get confused. And while he's marking them, may I ask the witness a question?
Yes, sure. I think he's got, how many pages is it?
Composite 19.
19 pages. We're making it a little simpler. This is coming from 9807, the phone.
I don't know which.
I'm going to tell you.
Okay.
Thank you. May I approach?
Yes, sir.
Spelled on this T-H-A-T, that. Correct?
Correct.
This is coming from the 9807 that the state has introduced thousands of pages indicating
Counsel specifying.
Overruled.
that it belongs, or it's a phone that Melly uses, correct?
Correct.
Page 1 of defense exhibit coming from 9807. Would you tell the jury how he spells that?
Dat, D-A-T.
D-A-T. Page 2. Will you tell the jury how he spells that?
D-A-T.
D-A-T. Not T-H-A-T, D-A-T, correct?
Right.
Page 3, coming out of 9807. How does he spell that?
D-A-T.
So when Melly spells the word that, you want me to go through all 19 pages? Or will you take my word that every time, coming out of 9807 that's attributed to this young man as writing the message, he does not spell it T-H-A-T, but D-A-T. Would you like to look through them?
No, sir. You're asking me to explain that the one moment he decided to use proper grammar.
One moment. These phones messages sitting there.
One at a time. All right. What's the objection?
Argumentative.
Overruled.
These phone messages that the state introduced sitting on this pages that we painfully went through, he spells it D-A-T, not T-H-A-T, except for this one occasion. Right?
Correct.
Huh, what a strange thing. I'm sorry, Judge. I apologize.
You have a paper clip, I see. Put it on the table.
Somewhat unusual, wouldn't you think? Okay. Before we get into your investigation totally, you became aware that the state employed or brought in the FBI to analyze these phones, correct?
Yes, sir.
They brought in the FBI.
Actually, correction, sir. They analyzed the cell site tower, not the actual phones.
Cell site towers so that they could tell the jury where these phones were located, correct?
Correct, sir.
Jameson, let's see for 1 second. Yes, sir.
Any trouble?
I don't know if you ask me if that's the defense is because he spelled that T-H-A-T instead of that. Like,
We're not discussing the case, don't form any opinion about the case, don't allow anyone to discuss the case in the presence of no research. Just leave your heads on your chairs, we'll be back with you shortly. Thank you.
they're not arguing. I did that. Doesn't mean that I would have argued. How do you know I did that means that I just committed a double homicide? How does the text say I did that mean double homicide? But he's arguing with the spelling.
All right, let the record reflect the jury stepped out, Counselor Manning along with the defendant. I understand that the defendant needs a restroom break, can we arrange it for that as well?
Thank you.
All right, anything to discuss, counsel?
Other than that, you can take that off the screen right now. No, sir.
I've asked somebody to come up to try to figure out why it won't show on the other thing. Being recorded.
Can I leave my notes right here?
Sorry with me. We're in recess.
Waiting on this nature, what's his name? Yeah, Nature Boy. Waiting on this Nature Boy trial to start. When is that starting? Somebody said it got pushed back because he got new charges or something. Ain't that what they said? He got new charges. Trying to get one of the girls to send a drone over to prison, jail. Trying to smuggle contraband into the prison. But they said the Nature Boy trial gonna be on Law and Crime as well. I'm definitely gonna follow that. I did hear though that they did drop some of the charges in the Nature Boy, some pretty serious charges at that, from what I understand. I'm gonna dig deeper into that. You know, it's a lot going on with this trial and in real life right now. So I done had a lot going on, man. I hope everybody good. Melly, on the other hand, I don't know. What do y'all think about his defense attorney coming off so, like, angry? I think it would have played better if he'd have just been a little bit more chill and, like, you know. But it just seemed like he can't. This is about to be interesting. They going to end up getting into it. For real, watch. But you can see Detective Moretti, he used to this. So he just kind of, he ain't really letting it affect him too much.
Welcome back. I'm Anjanette Levy, and you're watching Law and Crime. We want to get you right back into court, where Detective Mark Moretti, the lead detective in the YNW Melly double murder trial, is on the stand. He is the state's last witness.
So it's clear on this page 1 and page 2, they go together.
Yes, ma'am.
And you did the calculations or adjustments for Eastern Standard 2 from UTC in this particular document?
Yes, ma'am.
So in terms of, without saying specifically what, was Mr. Gambino offering merchandise to be sold to the YNW Melly account?
Yes, ma'am.
Was it real estate?
No, ma'am.
Were they physical, tangible items?
Yes, ma'am.
Okay. So going forward to the dates and times in question. When you're going through on this, I want to make sure it's clear that this first line corresponds to the page numbers. And where are you getting those page numbers from when you generated this document?
Top right-hand corner of the records provided to us from Facebook.
Okay. And this particular conversation were you able to go through and isolate all of the information on this thread ID?
Yes, ma'am.
So with your permission, I'm going to go through, if we can just, if it says sender PZ Gambino, I will read it aloud, and if you would respond with whenever the sender is YNW Melly.
Okay.
So first message, 10/19/2018, 1906, sends a photograph from PZ Gambino.
Then 10/19/2018 at 1907, a message from the account of YNW Melly to PZ Gambino, tell him 450.
10/19/2018, 1911, PZ Gambino, he say 5.
10/19/2018 at 1911, YNW Melly, 475.
10/19/2018, 1929, PZ Gambino, say less.
10/19/2018 at 1932, YNW Melly, 480 at the most. 10/19/2018 at 1938, YNW Melly, what'd he say?
All right, we're getting into some other testimony, but in real time, the court is on a morning break. So we want to check in with Law and Crime's Terry Austin. Terry, good morning again. Bring us up to speed on what the jury has heard so far this morning.
So far this morning, the prosecution, Christine Bradley, was doing her direct exam of Mark Moretti. He's the lead detective. And they got to the point that I think we've all been waiting for. During her opening, she said that Melly said, "I did that. Shh." And so we just heard text messages between PZ Gambino and YNW Melly, where, in fact, YNW Melly does say on the other side, "I did that. Shh." But she stopped there. She finished her direct exam of Mark Moretti. He's been on 2.5 days, but she concluded right there to underscore that point. Cross-exam.
I got it. Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our jury. The defendant, Mr. Clemens, his counsel, the assistant attorney, the witness, Detective Mark Murray, remains on the witness stand. Counsel will approach. I think you're on your, just to commence your cross-examination. If you're ready, you may proceed.
Thank you. When we took the break, we were talking about the state bringing in the FBI to plot out where the phones were. You remember that?
Yes, sir.
And the reason they brought the FBI in is because the FBI has a special unit to map out and plot where phones are. And they do that not only in this country, but all over the world.
Correct.
And the FBI agent they brought in was, in fact, Special Agent Collins. And you met with him.
Yes, sir.
And he was from the CAST unit.
Yes, sir.
Which stands for Cellular Analysis Survey Team.
Yes, sir.
And that is a unit that is brought in not only throughout the United States, but throughout the world to plot out and find the location of phones. Correct?
Correct.
And and to render opinions as to where the phones are located at a particular time.
Correct.
Now, were you aware that in order for him to do that, one of the things he needed was the name of the cell provider, correct?
Yes.
And the list of towers in the particular area that he's trying to locate the phone?
I don't know if he needed the list of towers, but that's standard.
Would it surprise you to learn that he needs not only the provider name, but the list of towers in a particular area so that he can attempt to map out and tell a jury like this where the phones are located at a particular time?
I have to disagree because the platform they use, CastViz, is linked with called NDCAC. It's the national database of all the cell towers that's maintained in the United States. So the platform they use is constantly updated. Now, when we use the platform we use, we have to update it periodically because more towers are added. So as for the fact that he needed it, I'm not sure about that, sir.
Okay. Are you aware that even though they are the Rolls-Royce of locating phones throughout the world, that they cannot pinpoint at a particular time exactly where a phone is at any particular time?
Correct.
They can only give a general area.
Correct, sir.
That general area is approximately a couple miles wide, correct?
No, it's more like meters as compared to miles. It's accurate, but it's not precise.
Now, you indicated to these folks that you looked at something on the cell records called environment.
Yes, sir.
And you use that as a guide to locate or plot where a particular phone is at a particular time, correct?
No, sir, that's inaccurate. The environment just tells us where the phone is interpreting where it's at. Example, it tells us if it's mobile, if it's outdoor, it tells us it's indoor. The environment has nothing to do with the location data. We use that in this case because every time we had an environment response from the T-Mobile records, I could corroborate it with video. Example, when he walked out of the recording studio at 3:18 a.m., the phone was registering outdoor.
How about when it was on I-75 or 595?
It was saying mobile. And if you would let me finish, every time the phone was registering outdoor, mobile, we had video to corroborate that. So he's walking, he's outdoors, it says mobile. I mean, it says outdoor. The second he gets in that vehicle and drives away, it switches over to mobile. On 595, we have video, mobile. On Pines Boulevard near the Monastery School, it says mobile. Passing McDonald's, mobile. After the shooting, after the murder, it's coming back east on Pines Boulevard, it's saying mobile. So we had video to corroborate that one little instant, that one little section of the box.
Are you aware that the FBI never, ever uses the label environment because they cannot attest to the reliability of that?
Well, I can't attest to how the FBI operates. I can't attest to their
Could
policy.
you just answer my question, yes or no, and then explain?
I sustain the objection.
Repeat the question, sir.
Are you aware, yes or no, whether or not you're aware that the FBI does not look at the environment because they cannot attest to the reliability?
I am not aware of that.
Fair enough. You also use latitude and longitude coordinates.
Yes, sir.
Are you aware that the FBI does not rely upon the latitude and longitude when they determine where a phone is?
The latitude and longitude that comes into play on the true call data report of the cell phone. It's an estimate. The cell phone provider is providing us an estimate where they believe the phone might be. Like we said before, it's not precise, but it's accurate.
My question to you wasn't that. My question to you is, are you aware?
Excuse me. What's the objection?
Badgering and being approached briefly.
Sure. Question.
Yes, sir. Are you aware, sir, that the FBI does not use the latitude and longitude coordinates when doing their analysis?
No.
Are you aware, sir, that the FBI never uses a cellular analysis by itself to prove a case?
Neither do we, sir.
All you are saying, basically, is that a phone may be in a general area, correct?
Correct, sir.
Cannot be 100% correct, right?
Correct.
And in fact, depending upon what tower it bounces off on, it could be totally incorrect.
There has been false readings with towers. There has been false readings with towers. And sometimes, anomalies within the records. It happens.
And we've heard a lot of talk about chat messages, and you read with both prosecutors various messages for what I perceive to be days, but hours. Days.
I would agree with you. It was long.
Long. And they would say, I'm going to pretend to be Mr. Smith, for instance, and you read the message coming from Judge Murphy, but I'll have you get in trouble. Not Judge Murphy. How about that gentleman in the back from BSL?
Okay.
And the messages were read and identified as those two people, the state and that BSO officer sitting in that corner.
Yes, sir.
Basically, right?
Yes, sir.
And you're aware, in order to really tell a jury who the person is, you need that person like this.
What's the objection?
Foundation.
Just name, rephrase.
you've had training in analyzing phones.
Yes, sir.
Somewhat, correct?
Yes, sir.
You have been an officer or a detective for some 20 plus years.
Yes, sir.
In order to identify someone's voice, you would need, legally in the courtroom, as you know, the person who made the phone call, correct?
Yes, sir.
Or the person who received the phone call. Did you ever speak to, what was his name, Gambino?
Yes, I did. Patrick Deloach is his real name. Deloach, D-E-L-O-A-C-H.
Now, in addition to that, you told this jury that you attempted to, well, you did get some cameras off of 595 and I-75, correct?
Yes, sir.
Could you tell the jury if you could see who was in each vehicle?
No, sir, you cannot tell.
Could you tell this jury how many people were in each vehicle?
No, sir, you cannot tell.
And you did get a surveillance from Montessori School, correct?
Yes, sir. And McDonald's.
And McDonald's. Well, on Miramar Parkway, for instance, the only surveillance you got was from the Montessori School, correct?
No, Montessori School was on Pines Boulevard.
Okay. Did you get any surveillance from any of the cameras on Miramar Parkway?
More specifics, or which one are you referring to?
Okay. How about the CVS that's on Miramar Parkway?
It doesn't cover up that far.
Did you pull it?
We went there.
Did you look at it?
Yes, sir.
How about Applebee's on Miramar Parkway?
Where's there Applebee's on Miramar Parkway?
On we're on Dykes Road. On Miramar Parkway West, on Dykes Road, on the intersection.
Yeah, there's a pharmacy there, but there's no Applebee's there.
Did you go to that pharmacy?
Yes, sir.
Did you pull the surveillance?
No, sir.
How about the Pollo Tropical?
Their videos didn't cover that area.
Did you pull them?
No, sir.
Did you look at them?
No, sir.
How about the gas station that's on Miramar Parkway?
The one just east of McDonald's?
Yes.
Yes, it did not cover the road.
How about the bank that was on the corner of 172nd and Miramar Parkway?
Did not cover the road.
Did you look at it?
Yes, sir.
Did you bring it in?
No, sir.
How about the four-way intersection where there's 4 cameras on 172nd Avenue?
Cameras covering the road.
Yeah, to see the cars driving through.
There's no traffic cameras at 172 and Pines. It seems to be a great misconception when people see those white boxes on top of the cameras. Those are actually control the traffic signals. They're sensors. The old sensors used to be in the road. They would burn out. The lights would not cycle properly. So, but there's no cameras. It's a great misconception.
Okay, then you said the vehicle turned right on and went south on 184th. Is that correct?
Which vehicle?
The Jeep?
Jeep never went south on 184.
Did it make a right turn on 184, the Jeep?
Yes, sir.
That would be north.
Yes, sir.
My mistake. Did you look at the camera at Publix that's on that road?
Doesn't cover the road, sir.
Did you pull it and look at it?
We went there, but it does not cover the road.
My question is, did you look at it?
Yes.
How about Sunset Lakes Elementary? That's there. Did you pull that camera, sir?
No, sir.
How about West Broward Elementary? Did you pull that camera?
Where's West Broward Elementary located at?
On South, on 184.
184 and what?
Pembroke Road.
Pembroke Road in 184?
Yes.
I don't know of a West Broward school there at Pembroke Road in 184.
Okay. How about the Walmart?
No, sir.
You didn't look at it?
No, sir.
How about the Audi Market?
No,
You
sir.
looked at that one?
No, sir.
How about the Walgreens?
No, sir.
We know that you pulled the Montessori school.
Yes, sir.
How about the Exxon? That's right down the street from there.
No, sir.
How about Somerset Academy?
No, sir.
How about the Tractor Supply Company on that street? Did you bother to look at that camera?
We're specifically on High Boulevard to Tractor Supply.
190 what? 192nd.
No, sir.
You missed quite a few cameras.
No, sir.
No. Now, you were told by Cortland Henry that the day of October 25th, several people went to the flea market to buy some weed, correct?
Yes, sir.
Certainly you went there to pull the tapes of the flea market so that you could show this jury, didn't you?
No, sir.
But you did a helicopter ride to show this jury this route on what day?
May 2023.
May of 2023.
Yes, sir.
After this trial started. Correct?
Suggestion.
You did this helicopter ride in May of 2023.
Yes, sir.
After this trial started, correct?
Correct.
And you did this drive-by in a car with a partner filming it. On what day?
March 2022.
That was 2 years after this incident?
4 years, actually, sir.
4 years. That's why I'm a lawyer and can't be an accountant. 4 years after this incident.
Yes, sir.
And that was all done at the request of the state of Florida, correct?
Correct.
The prosecutors in this case, correct?
Yes, sir.
4 years after the incident.
Yes.
4 years after this young man.
Excuse me? Thank you. Just say.
4 years after this young man surrendered, correct?
Sustain the objection. Ask your next question.
Let's look at Exhibit 115, if I can find it. That's the blue phone, I think, that was in the vehicle.
The black LG phone. The blue phone belonging to Chris Thomas, or the one belonging to Anthony Williams, or the one was in the back seat rest?
Okay. I need a lot of you find me 150. I think it's exhibit 115. That's the phone that was the third phone found in the car, correct?
Yes, sir.
That you said you don't know who the owner is, correct?
Correct, sir.
During one of the breaks, I asked you to open that phone, correct?
Yes, sir.
And there was a SIM card in there, correct?
Yes, sir.
And that SIM card has a serial number on it, correct?
Yes, sir. Do we help you find Johnson?
If you could, yes. Could you step down to help?
Yes. Is in one of the others?
I'm too old to say, but yeah.
Very good.
Thank you very much.
Thank you. Okay.
Thank you.
That's okay.
May I approach?
Yes. 115, Robert.
That is 115, State's Exhibit 115. Could you open that, take that phone out, please?
Yes. I'm just going to put gloves on just because there was blood on at one time.
I don't blame you. Was that phone, while you're pulling it out, analyzed to determine whose blood it was?
Yes, sir. We took it to HIDA, High Intensity Drug Trafficking Agency, and they had them attempt to analyze the phone. It's completely broken.
Could you open that phone like you did during when I asked you to? Don't pull out your burglary key now.
It's not a burglary tool. That should be a burglary, sir. I don't want to lose it.
Did you pull it out?
Yes, sir. It's right here.
Could you pull out this? Did you pull out
Yes,
the SIM
car's
card?
right here, sir.
Could you read the serial number off of that, sir?
89012000080218727. It looks like there's an 80.01A.
Okay. Could you, with the court's permission, let the jury see that SIM card?
You want to publish it to the jury?
Yes. Let him hold it.
Any objection? All right, you can step down. Executive.
Just good.
I don't know how to work the computer. I'd rather him just show it to the jury.
You may step down. Thank you.
That's what a SIM card looks like. That's how the phone communicates with the tower. It's the serial number we just
Turn it
read.
up, please.
And that's the.
Yeah, we're going to make it because
Now you do it to me.
I just wanted you to get some exercise, quite candidly.
There's no blood on this. This is safe, sir. What do you want to put that right here?
wherever you can, wherever it's published on the screen.
Put it up there.
Okay. We're going to leave it there for a second. I'm sorry, may I approach? I apologize. That's the serial number, correct?
Yes, sir.
And it goes to a Sprint phone, correct?
Yes, sir.
You're aware that that SIM number can be tracked once you have the provider
Yes, sir.
to a particular phone.
Yes, sir.
Did you do that in this case?
No, sir.
Fair enough. You could take that SIM card back.
Can I step down now?
Yes, you may.
Now, I'm sorry, tell me when you're ready. You can put it back in the 115, the bag.
It's going to take me a few minutes. I'll wait till the next break. If you want to.
I don't want the clerk to get in trouble, so just put it back in there. Let me return it to the table. The clerk's watching very carefully. Thank you. Now, what I'd like to do is somewhat go in chronological order of your investigation, if I may. You get a call on October 26, 2018 to report to the Memorial Hospital, correct?
Yes, sir.
When you get there at about 6 o'clock in the morning.
Yes, sir.
At 6 o'clock in the morning, you speak to the first officer, which would have been Officer Amador.
Yes, sir.
And also on the scene is Detective Bertram and Bermudez.
Sergeant Bermudez, yes.
Sergeant, I apologize. And you are assigned the lead detective role.
Yes, sir.
And that is like a conductor in an orchestra. Right?
I wouldn't categorize that, but...
Now, are pictures taken of the two individuals that were shot before they were removed from the vehicle, the Jeep?
Yes. No, sir.
You immediately go and speak to Cortland Henry, correct?
Yes, sir.
And we listened to the tape of Mr. Henry.
Yes, sir.
Who told you that there were 3 people in his car, correct?
Yes, sir.
Cortland Henry, the driver, correct?
Yes.
Christopher, and, well, let me get in the right order. In the front passenger seat was Anthony Williams.
Yes.
And sitting in the rear passenger seat was Christopher Thomas.
Yes.
Only those 3 people when the shooting occurred, correct?
Correct.
You learned that he lied to you about where the drive-by shooting was, correct?
Yes.
You went to, what, 3 different areas to look for evidence of the drive-by of Cortland, what Cortland Henry told you, correct?
Yes.
You learned at that time that at first he was labeled a victim, but that he now is lying to the police concerning the shooting of 2 individuals.
He was still listed as a victim that day, even though we knew he was lying to us, but he was still considered a victim at that point.
There is such a crime as lying to the police, correct?
Yes, sir, it's a misdemeanor.
You could have arrested him if you so chose for lying to the police, correct?
You're saying I should have arrested a potential victim of a violent crime on a misdemeanor?
Could you just answer my question? Could you have arrested him, yes or no?
Yes.
And you spoke to him for approximately an hour or 2, correct?
It was about an hour.
Okay. And he gave you the address where he lives, correct?
Yes, sir.
And that address was 18521 Southwest 44th Street, Silver Lakes?
Yes, sir. No, Sunset Lakes.
Sunset Lakes. But he gave you the home address.
Yes.
And he tells you also that Melly lives there, correct?
Yes.
He tells you Anthony Williams, one of the victims, lives there.
Yes.
He tells you Christopher Thomas, the other victim, lives there, correct?
Correct.
And he also tells you that Melly is a recording artist, correct?
Yes.
And we learned from the testimony that $16 million went into Jameson Francois' bank account.
Over a 30-month period, yes.
Okay. So, and he was the business manager of this 19-year-old young man.
Yes.
You learned later, correct?
Yes.
A rather successful, would you say, recording artist.
I really don't understand the music business, sir. I don't know how the money's made, how it comes in.
I'm not asking you that. Someone who earns $16 million in 30 months legally is pretty successful, wouldn't you say?
Well, I don't, like I said before, that we could never determine the amount of money, what was, because Mr. Francois had other clients, so we could never isolate what specifically is made by one artist over another.
Okay.
We just knew the money was there.
So, you knew that the 2 victims, the driver of the car that lied to you, and Melly lived, and you had the address at the same house.
Yes.
You also learned about that time, and you mentioned it briefly, that a text message came out from a Crucial Almighty.
Yes.
And that text message was, we were just aiming at YNW, correct?
Yes, sir.
And it had a picture of him with a target, correct?
Yes, sir.
So it would be fair to say on October 26th of 18, Crucial Almighty, which his real name was David Hedgepath, was suspect number one based upon that.
It was a person of interest. It was something to look at.
When did you, since you knew this, on October 26th of 2018, when did you decide to talk to the David Hedgepath, Crucial Almighty, who said he shot at this young man inside a Jeep? What date?
I first did a search warrant into his social media account where the comments came from, which then we were able to determine a better picture of Mr. Hedgepath was. So it was probably maybe 2 years later when we interviewed Mr. Hedgepath.
2 years later. That would be in 20?
Yes, sir.
A year after this young man surrenders to you, to the police?
I'm not sure the exact date, but
February of 19.
okay.
Would you agree it was 2 years after that?
Yes, sir.
And you interviewed him after the case was closed, correct? Because it was closed at the time of the arrest.
Yes, sir.
Of Melly, correct?
Yes, sir.
Do you subpoena any records from him?
His work records.
And when do you subpoena those work records?
2 years later, after we interviewed him.
Okay. And I think you introduced him as. Did you speak to any of his co-employees to verify whether or not he was really working when the time clock indicated he was?
Yes, sir.
No. You also learned from Cortland Henry that they were having a problem with a guy named Benton.
Yes.
I'm going to label him as suspect number 2. Who is Bentley?
You never could identify him.
So last name unknown.
Correct.
You also learned that there was a problem at Walmart where they got jumped and I think a necklace or a bracelet was stolen.
A little pendant fell off one of them, yes.
Okay. Did you go to Walmart to investigate that?
No, sir.
I'm going to make him suspect number 3 so far. And I'm going to just label him Walmart with a question mark. Fair enough?
Fair enough.
Did you bother to go and attempt to pull the surveillance of Walmart because they keep their tapes for a while?
Not a while, sir, but usually about 30 days.
Did you go to Walmart to attempt to see if it even didn't exist?
No, sir.
Now, you then, during October 26th, get the surveillance tape of the people coming out of the recording studio, correct?
On which date, sir?
The 26th.
Yes, sir.
You respond to the hospital in the morning.
Yes, sir.
By mid-afternoon, you get the surveillance tape, correct?
Yes, sir.
You identify, do you not, by the end of October 26th, all 8 people that left the recording studio?
I think we had more like the 27th, everyone was pretty much identified.
Okay. By October 27th, you identified Cortland Henry, correct?
Yes, sir.
Anthony Williams,
Yes, sir.
Christopher Thomas,
Yes, sir.
Trevon Glass,
Yes, sir.
Melly,
Yes, sir.
I'm missing 3
Jacoby Mills and
Jacoby Mills,
Dontavius Withers
Dontavius Withers, and Adrian Davis. All 8 people that left the recording studio, and 2 had passed away, correct?
Yes, sir.
And you knew where all 8 of them were living, correct?
Yes, sir.
And that was at the 18720, whatever that address I read off before.
The Sunset Lakes 184 Southwest 44th Street.
You had that address, correct?
Yes, sir.
And you had observed the bloody scene of inside the Jeep, correct?
Correct.
And you knew that Cortland Henry had lied to you.
Correct.
So you certainly, at that point, obtained a search warrant to look at that house to see if you could find any blood, any gun, or anything to tie up what happened in that car, correct?
There is no way we could have got a search warrant for that house because there was no nexus to the crime to the house. And I have to establish a nexus between the two, or the judges will not sign the warrant.
Did you even try, sir, to get a search warrant and go in front of a judge and say, I got 8 people who left the studio. They all live in the same house. The driver of the vehicle we interviewed lied, and the inside of the Jeep is covered in blood, and we're looking for the gun or guns and the bloody clothes involved in this. Did you bother to do that, sir?
So like I said before, there was no connection between the house and the crime itself. Now,
The answer...
where we had blood, where we had evidence, where we had instruments of a crime, we did search warrants. Anytime we had a nexus between the two, we did a search warrant. We never had a nexus between the two. We even went to that house that day, knocked on the door, there was no one there.
You could have secured that house by officers standing in front of it and at least come to this jury and say, I went to a judge explain to the judge 8 people live in a house, 8 people left the studio, and a few hours later, 2 people ended up dead, and the driver of the vehicle lied to us about everything concerning the shooting. You could have done that, couldn't you?
No, that's not how that works, sir.
Not how it works. Fair enough. Did you get a search warrant of the house in November at all?
You mean for which house, sir?
The house where Melly lived.
No, sir.
How about December?
They were already gone at that point.
You could have looked for blood, traces of blood, because we saw that you sprayed this agent on things and miraculously blood surfaces. You know that.
Yes, sir.
Did you do that?
No, sir.
You mentioned to the state that you spoke to an Adrian Davis and a Dontavius Withers, correct?
Yes, sir.
They were the 2 of the individuals that originally left the studio
Yes, sir.
and got into the red Mitsubishi.
Correct.
You learned from that. I haven't even asked a question.
Hey, watch himself. Take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. So no research. There's no case on your jurisdiction. Thank you. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. Mr. Dempsey, the restroom break. All right. Thank you. We're in recess.
Recess.
Welcome back. I'm Anjanette Levy, and you're watching Law and Crime. We want to get you right back into court in the YNW Melly double murder trial. Detective Mark Moretti of the Miramar Police Department, he is the lead detective in this case in the murders of Chris Thomas Jr. and Anthony Williams, known as YNW Juvie and YNW Sack Chaser. He is on the stand right now, and he is under cross-examination, so let's listen in.
That the FBI does not use the latitude and longitude coordinates when doing their analysis.
No.
Are you aware, sir, that the FBI never uses a cellular analysis by itself to prove a case?
Neither do we, sir.
All you are saying, basically, is that a phone may be in a general area, correct?
Correct, sir.
Cannot be 100% correct, right?
Correct.
And in fact, depending upon what tower it bounces off on, it could be totally incorrect.
There has been false readings with towers. And sometimes anomalies within the records. It happens.
And we've heard a lot of talk about chat messages, and you read with both prosecutors various messages for what I perceive to be days, but hours, maybe. Days.
I would agree with you. It was long.
Long. And they would say, I'm going to pretend to be Mr. Smith, for instance, and you read the message coming from Judge Murphy, but we get in trouble. Not Judge Murphy. How about that gentleman in the back from BSL?
Okay.
And the messages were read and identified as those two people, the state and that BSO officer sitting in that corner.
Yes, sir.
Right?
Yes, sir.
And you're aware, in order to really tell a jury who the person is, you need that person like this.
What's the objection?
Foundation.
Sustain, rephrase.
You've had training in analyzing phones.
Yes, sir.
Somewhat, correct?
Yes, sir.
You have been an officer or a detective for some 20 plus years.
Yes, sir.
In order to identify someone's voice, you would need, legally in the courtroom, as you know, the person who made the phone call, correct?
Yes, sir.
Or the person who received the phone call. Did you ever speak to, what was his name, Gambino?
Yes, I did. Patrick Loach is his real name. Deloach, D-E-L-O-A-C-H.
Now, in addition to that, you told this jury that you attempted to, well, you did get some cameras off of 595 and I-75, correct?
Yes, sir.
Could you tell the jury if you could see who was in each vehicle?
No, sir, you cannot tell.
Could you tell this jury how many people were in each vehicle?
No, sir, you cannot tell.
And you did get a surveillance from Montessori School, correct?
Yes, sir. And McDonald's.
And McDonald's. Well, on Miramar Parkway, for instance, the only surveillance you got was from the Montessori School, correct?
No, Montessori School is on Hines Boulevard.
Okay. Did you get any surveillance from any of the cameras on Miramar Parkway?
More specifics, or which one are you referring to?
Okay. How about the CVS that's on Miramar Parkway?
It doesn't cover up that far.
Did you pull it?
We went there.
Did you look at it?
Yes, sir.
How about Applebee's on Miramar Parkway?
Where's there Applebee's on Miramar Parkway?
On Dyke, I'm sorry, we're on Dykes Road. On Miramar Parkway West, on Dykes Road, on the intersection.
Yeah, there's a pharmacy there, but there's no Applebee's there.
Did you go to that pharmacy?
Yes, sir.
Did you pull the surveillance?
No, sir.
How about the Pollo Tropical?
Their videos didn't cover that area.
Did you pull them?
No, sir.
Did you look at them?
No, sir.
How about the gas station that's on Miramar Parkway?
The one just east of McDonald's?
Yes.
Yes, it did not cover the road.
How about the bank that was on the corner of 172nd and Miramar Parkway?
Did not cover the road.
Did you look at it?
Yes, sir.
Did you bring it in?
No, sir.
How about the four-way intersection where there's 4 cameras on 172nd Avenue?
Cameras covering the road.
Yeah, you see the cars driving through.
Those
Cross-examination underway. Stuart Adelstein is really taking aim at Detective Moretti, what he did do, what he didn't do. He obviously has a standing objection, Philip, to all of this Instagram stuff coming in through this witness because it wasn't authenticated by somebody from Instagram or by somebody from whatever mobile company, T-Mobile, what have you. I mean, we did see a cell phone company representative earlier in the trial. But he's almost like questioning him about a legal argument in front of the jury. So how much weight do you think the jury is going to go for this whole issue of the defense objecting because they don't believe these messages were authenticated properly?
If he does not bring in anybody in the defense case to refute this, it's going to come off as window shade.
Jurors entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of defendants, defendants, counsel, the assistant attorneys. Ladies and gentlemen, the jury, our witness Detective Mark Marty remains on the stand. Counsel, if you're ready to continue with your cross, you may.
Thank you. I think we were on October 27th, but I want to go back to October 26th for a moment.
Yes.
You leave the hospital. You go to various areas to look for a drive-by. And you learn that Courtney Henry lied to you. Okay?
Yes.
Do you not get a search warrant for the Jeep?
Yes, sir.
And in fact, the Jeep is searched on October 26th, correct?
Yes, sir.
And the purpose of that was to photograph it, correct?
Yes, sir.
Process it for fingerprints and DNA,
Correct.
and to collect all the physical evidence within inside the Jeep that could lead to who did this, correct?
Correct.
And that was done over several hours, correct?
Yes, sir.
In fact, it was done by at least 2 crime scene technicians.
Yes, sir.
Now, there was also the red Mitsubishi that was seen leaving the area, correct?
Yes, sir.
With several people, correct?
Yes, sir.
That you ended up interviewing over the course of this investigation, correct?
Yes, sir.
Did you, in fact, search the red Mitsubishi at any time?
No, sir.
Did you, in fact, process the red Mitsubishi to get fingerprints to determine who was inside that vehicle?
No, sir.
Had you done that, you could have obtained DNA.
Sustained.
If you did that, that could verify, would it not, whether or not Melly got inside that vehicle. Right?
Not necessarily.
But it could have.
Possibly, yes.
October 27th, I think we were done at. You interviewed, as you've indicated, Dontavius Withers again, correct?
Yes, sir.
At the end of October 27th, Melly was not in the Jeep during the shooting, according to your investigation, correct?
Repeat that question.
At the end of October 27th, your information indicated that this young man was not in the Jeep at that time when the shootings occurred, correct?
That was based upon the false statement of Dontavius Withers.
You say false statement. You have Cortland Henry who told you this, that he wasn't there, correct?
Sustained.
If you learn that the day of them going to the studio, that Christopher Thomas and Anthony Williams went to the flea market?
I don't know which two went. I could have sworn Dontavius went to the flea market. Maybe it was Chris Thomas and Anthony Williams.
And you've already indicated you don't go there to verify or prove or disprove.
Correct.
On October 31st is when you obtain a warrant on David Hedgepodge's Twitter account. I think you testified. All right.
Yes, sir. You said October 31st?
Yes, sir. Halloween day. Correct?
Yes, sir.
But you don't interview him until 2 or 3 years later.
Correct.
On November 1st, you again searched the Jeep, correct?
Yes, sir.
So that's the second time you've searched this vehicle, correct?
Yes, sir.
The 26th, and now November 1st, correct?
Correct.
And again, that is to collect any evidence, process it. If you missed any evidence.
No, so if my recollection stands correct, the second search warrant was for a trajectory analysis to be conducted by Mr. Kelly.
On November 2nd, you interviewed, do you not, Christopher Thomas Sr.
On which date?
November 2nd.
November 2nd, Chris Thomas Sr.?
Yes.
Oh, at the funeral. Yes, sir.
And without telling us what it is, what he told you, you discovered there was a problem.
Hearsay.
Mistake. Do you find out that Christopher Thomas Sr. had issues with Anthony Williams?
Sustained.
Do you ever investigate Anthony Williams, Sr.?
Can you repeat that question, sir?
Do you ever investigate Anthony Williams, Sr.? Christopher Thomas, I'm sorry. Sr.
No, sir.
I'm going to make him suspect number 4.
Okay.
On November 18th, based upon your phone analysis, and going through the various phones, you get some mapping that the shooting may have occurred at a trailer park, correct?
One cell phone, the cell phone of Chris Thomas, hit off of a cell tower near a trailer park, Holiday Park. But we didn't have anything to accompany those other than a cell site in the sector. So that was all we had to work with at that point, was that one general area.
Could you answer my question? On November 18th, based upon whatever analysis, you go to Holiday Park, trailer park, correct?
Yes, sir.
And that's based upon some analysis of a phone, correct?
The cell tower, cell site, yeah, sir.
You find absolutely nothing.
Correct.
And you learn that basically you went on a wild goose chase based upon your analysis of that one phone, correct?
Yes, sir.
Approximately 1 month later, on November 21st, you find the scene with the 8 casings, 8 projectiles.
8 spent casings, sir. Projectiles and casings are different.
I get those terms confused. I apologize. And we saw about 50 pictures of those 8, what are they?
Casings.
Casings. Correct?
Yes, sir.
Looking at the south end, the north end, the east end, and the west end, right?
Yes, sir.
Seven days later, do you search the Jeep again?
I'm not sure when we went back to the Jeep.
If I showed you something that would refresh your recollection?
Yes, sir.
Let's see if I can find it. Can I find it, John?
Yes.
May I approach?
This section.
May I approach?
Yeah, just identify what you're approaching with.
I'm looking at a report and a timeline. May I?
Yes.
On the 8th, trajectory rise. Compass.
Yeah.
Okay. Okay.
So on 11/28, you go back to the Jeep for the 3rd time, correct?
Yes, sir.
On December 4th, based upon the analysis of various phones or whatever, you, along with Miami-Dade Police and ATF, search a canal off of I-75, correct?
Yes, sir.
And that was based on some pinging or mapping of the 9807 phone, correct?
It was not the pinging, that's improper terminology. It was the true call data, which placed the phone near the C9 canal.
And both Miramar Police, Miami-Dade Police, and ATF, after searching the canal, find absolutely nothing.
Correct.
December 5th of 18, you meet with the medical examiner, correct?
Yes, sir.
Now, approximately 3 months later, January 27th of 19, you execute a warrant on an apartment located at 5700 Tuscan Place, apartment number 307, Margate, Florida. Correct?
It was the 28th, sir.
The 28th, not the 27th?
Correct, sir.
Okay, I stand corrected. On January 28th, you execute a warrant on that apartment.
Yes, sir.
That is an apartment belonging to Jameson Francois and Adira Scott, correct?
Yes, sir.
That's the same Jameson Francois that had some $16 million in his account. We're talking about the same person, correct?
Yes, sir.
You go there 3 months after the shooting with BSO officers, correct?
Yes, sir.
ATF officers.
Yes, sir.
K-9 officers.
Yes, sir.
And the SWAT team.
Yes, sir.
In that apartment owned by or rented by Jameson Francois, you find a 40 caliber round, do you not?
Yes, sir.
You also find a storage key, correct?
Yes, sir.
That leads to a locker, a storage locker, correct?
Yes, sir.
You in turn execute a search warrant on that locker.
Yes, sir.
I think it's storage unit 5, if I can read my writing, 509, located on South State Road 7 in Margate, correct?
Correct, sir.
Now, I noticed it wasn't mentioned, or maybe I missed it, but in that locker you found, did you not, a black holster, correct?
Yes, sir.
You found another black holster with a Glock back strap on it.
Yes, sir.
And a black holster with a magazine holder.
Yes, sir.
And various gun locks, correct?
Yes, sir.
No guns.
No guns.
Without telling us, you never, ever interviewed Jameson Francois to ask him about the 3 black holsters found in that locker, correct?
I interviewed him after that incident.
You never asked him about those black holsters found in there, correct?
I'm not sure, sir.
You're not sure. And you never asked him about the gun locks, correct?
Correct.
And you never, ever, as we sit here today, know where those guns that were locked in his storage unit are, correct?
Correct.
And then on January 27th, I think you testified Cortland Henry was arrested in Texas, correct?
Correct, sir.
You went out there, correct?
Yes, sir.
You knew he had a lawyer, correct?
Yes, sir.
And you went out there to question him, despite the fact that you were aware that he had a lawyer,
What's
correct?
your objection?
May we approach?
Sure.
Proceed, Your Honor.
Yes.
You went out there, sir,
Yes, sir.
knowing he had a lawyer, correct?
Yes.
And you went out there to question him about this case, correct?
His rights were never invoked.
In fact, you were escorted out of the jail because the yelling between you and he got so loud that the guards asked you to leave, correct?
No, sir, that's a false statement.
False statement. Now, there came a time that you issued a warrant for this young man's arrest, correct?
Yes, sir.
And the people that generally execute that warrant are the U.S. Marshals.
Yes, sir.
And you gave them a picture of this young man, which is, of course, standard operating procedure, correct?
Yes, sir.
And they, in fact, based upon the picture that you gave them, took someone into custody for a short period of time.
Sustained.
The person that the marshals took into custody.
Sustained objection.
Do you know the person that the marshals took into custody based upon your picture that you provided?
I sustain the objection.
Your Honor,
Still
further
opposed.
instruction.
Counsel, ask your next question.
On February 13th, Melly voluntarily surrendered, correct?
Yes, sir.
On February 14th, you conduct another search on US 27 and Johnson Street, correct?
Yes, sir.
That's also based upon your so-called analysis of various items that you looked at, correct?
Yes, sir.
Tell this jury what you found.
Nothing.
Mayor, maybe approach?
Sure.
May I proceed?
Please.
On February 25th of 19, you execute a warrant on Jameson Francois' car, correct?
Yes, sir.
That was a 2016 Kia?
Kia Optima.
Huh?
Kia, yes, sir.
And find absolutely nothing relevant to this case, correct?
Correct.
No blood stains at all, correct?
Correct.
Nothing pertinent to this case.
Correct.
On February 28th of 19, you, along with the assistance of, I think, the state, bring Jameson Francois into the state attorney's office, correct?
Yes, sir.
And miraculously, you get this phone 9807
Yes, sir.
from Mr.
Francois.
Jameson Francois, correct?
Yes, sir.
You have, as we sit here today, no idea how long he had that phone, correct?
That's not true, sir. We kind of from the interviews in the cell, in the interview from the jail calls tell us when it was when the defendant talked to his mother and told her they need to get the phone over to track, which was Jameson Francois. So it was right about that time that we got transferred over.
May I have one moment? Or this would be a good time to break for lunch, so I can locate it.
All right. Ladies and gentlemen, we'll take our lunch and recess now. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence or no research. We'll see everybody back at 1:15. Please don't pay those chairs. Have a nice lunch. Thank you. clerk to bring that down. Councilor May along with the defendant. Counsel, I'm not trying to rush you or anything like that, but how long do you think you have on your cross approximately?
Give me 1 second.
Sure.
And let me look at my notes. I'd say between an hour and a half to 2. Hopefully closer to an hour and a half.
So, how much redirecting you might have?
30 minutes or so?
Pardon me?
30 minutes or so?
So, are you calling your witnesses?
Yeah.
So, are you going to have witnesses this afternoon? Get somebody in here?
We would ask to start our case tomorrow morning, if that's possible.
It's always possible.
All right, Dave.
What about witnesses today, though? You don't think that there's, you have somebody available? And I know you know, there's issues with experts. I'm not talking about experts.
No, we would need till tomorrow morning.
You need to tomorrow.
Yes, sir. I'm not trying to be difficult there. I didn't anticipate, we did not anticipate the state would be that brief this morning with the detective.
So you call, assuming, you know, that that it goes as planned today,
We'll be ready to rock and roll tomorrow morning at 9 o'clock.
Okay. All right. Anything to discuss, Council?
The council be so kind as to tell me who they are calling, as I've been gracious enough to tell them.
We will when we make the final decision. Fair enough?
Fair enough?
All right. Have a nice lunch. We're at recess.
Is trying to use in Florida to take the life of Melly in terms of the phone and the cell towers. And also I was impressed with the that versus that, because obviously the argument will be the state cannot prove that that was Melly that said I did that, because he never uses the word that. Just take a look at some of the texts we had read in this trial. And I was also impressed by the fact that if you're going to take the life, why not go get the cameras? You know, let's talk about Idaho, for instance. They went and got cameras from everywhere. Go get the cameras to see and place people, because there are cameras everywhere. That was not done, and I think the defense did make inroads into this examination. Now, you may not like the style, but the jury may not care about that, because they're going to say, I want to find the facts for myself. I don't care if you're rude. I don't care if you're argumentative, but maybe you should be if you're seeking to take the client's life.
I thought that was an interesting point, Linda. I agree with you. The fact that they didn't go to Walmart or Tractor Supply or these other places to get the video, because typically, it's my understanding, you would send like a beat cop out or somebody, or you'd issue a subpoena and you'd canvass the area and you'd say, hey, do you guys have surveillance video? And then you'd get a subpoena for it, or you know, what have you. So Mina, I want to know what you think so far of the testimony, particularly the point on cross-examination that Linda highlighted here. I found that interesting as well. The difference between the DAT, D-A-T, the slang, and T-H-A-T, that was used in the I did that, shh. We saw all of these other messages in which Melly is texting and messaging people, which he used D-A-T, DAT.
I agree. I think it was a highlight in this cross here. And this was the one piece of evidence that they had that's sort of an admission, right, is what the prosecution is trying to allege. And I think that defense attorney Adelstein really just shredded that by pointing that out. This is not how he speaks. And I thought that was very, very strong. I also think it's very strategic that he keeps reminding the jury that Cortland Henry did lie. And I thought it was really good as well that he brought up the point, did you search the home? They all live there. you know, Cortland arrived to the hospital with what seems like a change of clothing. So I thought that was a great way to poke holes in what the detective has been saying, and definitely raised a lot of questions in my mind.
Well, it will be interesting to see where it goes throughout the afternoon. We're going to start taking your questions now, and we'll check in with Terry Austin when she gets set up. That lunch break happened pretty quickly. Our first question comes from Carrie Trinan from YouTube, Linda. The state is using non-experts, meaning Detective Moretti. They say he's not an expert in this, the defense does. How is this allowed when the FBI can't even such data? Please explain to me how this is even allowed. So I think they're saying that Moretti is using data that the FBI doesn't even use or can't use.
That's right. The FBI has the task force. They specialize in this, and they say that data is not reliable. But the state of Florida says, and you know, it has a lower standard, a lower burden to admit what would be called expert explanations through their lead detective. And so that's how it comes in. But when you do that, there's a danger. And the danger is this, Anjanette. Not only does it mean he may not know what he's talking about, not only may it seem that they're trying to use data that the FBI wouldn't use to take the life of the client here, but when I first got on today and I tweeted about this, what shall I say, lead detective, when he was asked to read those text messages, called Jamell Demons demons, and the prosecutor quickly changed it. And I thought that showed a bias to the rest of his testimony that's going to affect the jury and affect someone like our questioner here that says, how is this allowed? Well, it's allowed, but it may be biased and it may hurt the state.
Mm-hmm. And this has come up a few times during the trial, Linda, the fact that, and we actually, you know, people have pronounced it both ways. We've heard demons and demons. Apparently the name is pronounced demons, but there have been several times in which, really, frankly, the state and the defense have said demons, maybe by accident, maybe not, but the defense is always quick to point out it's demons, and they object. So this has come up many times. Let's get to our next question from it's_TFabs from Instagram. Didn't the prosecution just lie about the text message that states, I did dat? Because I remember in the prosecution's opening statement, they said that Melly admitted to the crime by saying, I did dat. But this one does not show an admission because, based on what the detective said, the question before the response was, are you okay? And it was weird that Melly said, I did dat. So did the state lie, in your view, Mina, by saying, I did that, when the message says, I did that?
I wouldn't say they lied. I would say they're reaching. And I think that's what we're seeing in this case. They're trying to piece together anything that they could find to point to Melly being at fault. When I actually, on day one, remember you, Anjanette, you and I did a sidebar podcast after day one. And I thought that was odd, too, that they would include that. They even included it in the opening statements, this text message of, I did that. But we still don't have context for this text message. All that was asked was, are you okay? To leap and say him saying, I did that, is somewhat of admission of guilt. I don't see anything else that even talks about him committing the murder. It's just, are you okay? So I don't think there's enough here. And, you know, I wouldn't go on and say the prosecution is lying. I do think that they're trying to use anything that they can on the phone to make him look guilty. And I think that the defense really just shredded that with their cross.
And Anjanette, can I add to that a second? That's important, because there was a question, did you talk to the person who uses the name on Snapchat Gambino, PC Gambino? And the detective said yes, but then I don't recall him being brought in to say, here was my conversation. Now, maybe he's going to be brought in and say, this is what I meant. But, you know, if you're having a detective interpret, as we've seen these texts that have been in, which have been kind of interesting to interpret, I think it also leads to another issue.
Well, we shall see, won't we? We're going to take a quick break, and when we come back, we're going to check in with Terry Austin and bring her into the panel. Keep your questions coming to us on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. We've got so many platforms now. You can reach out to us on all of them. Stay with us. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and you are watching Law and Crime, and it's now the lunch hour in the trial of YNW Melly. We are taking your questions, so keep them coming to YouTube, Facebook, Twitter, TikTok, Instagram, and Threads, and we will get to as many of them as we can. But before we get to your questions, and they are always great, we're going to check in with Terry Austin, who is now joining us. Terry, what's it been like this morning in the courtroom, both for the direct and now the cross?
Well, the last part of the direct by Christine Bradley was talking about, I did that, shh. And she was trying to emphasize what she said during her opening statement, which is that Melly was admitting to the crime. However, on cross-examination, I think Stuart Adelson was trying to say that, in fact, it probably was not written by YNW Melly because it wasn't spelled the same way that he spells the word that in 19 other pages of messages that he did between a billion other people. He spelled it dat, D-A-T. So they're trying to put some doubt in that jury's mind. The prosecution is trying to say this was an admission. Mark Moretti was also on the stand during cross before we took that lunch break, and he's going through various other messages. And I think what the defense is trying to do here is to establish that that investigation was not done well. He said basically that he used longitude, latitude, and the defense was trying to say, well, that's not something the FBI would do. He was trying to say he used environmental concerns, and that was something, again, that the FBI would not do. And he's also trying to say that he did not go further in the investigation by interviewing people who could be suspects. He went through 3 different people, suspect 1, suspect 2, suspect 3. The first suspect basically was someone who said online, this was someone who said, look, he was the one who did it. And the witness had to admit, I basically didn't follow up till much later after the incident. So I think the bottom line is, 1, the investigation was not done well, and 2, that the techniques that were used were not the proper techniques. So that's what the defense is trying to do right now. We're on a lunch break, and we'll go back at it, and there'll be more cross-examination of Mark Moretti.
Will be interesting to see where the defense goes next. Linda, I'm going to throw this next question to you. I think it's a really good one. It comes from Graham Turner from Facebook, and he asks, can they tell the difference between standard text and speech to text? Meaning, was this dictated or was it typed? Specifically thinking of dat, D-A-T, versus that, T-H-A-T.
Okay, so I'm not an expert, but I thought it was such a great question. I kind of looked it up. If you have the phone, you can tell when the microphone has been put on, and then you have to coordinate it with maybe the text that was done. But if you're just going to get the records themselves, they will not show you how the text was put into a text, whether it was by speech or whatever. So I don't know if that coordination was done. So here, what both sides are doing, though, since this is the only that Melly had, which is a great question, because maybe if you're dictating it, it comes out as that. When you're typing it, you always say dat. But in the other, we talked during break, in the other important text here between Trevion Glass and Melly about whether or not he did the shooting. Now, I won't read the whole text, but he said he would never do nothing, it's nothing, but none like dat, D-A-T. And he uses the word dat in that text a number of times, because he says, or else people will go to war or whatever over it. So I think that the prosecution does not have the coordination between whether or not something was dictated or not here on an Insta, and the defense is going to say, hey, look, you can't use that. It's not him. It's clearly not him, because he doesn't speak like that.
Mm-hmm. It'll be interesting to see if this is possibly something that comes up on rebuttal, if they can even tell this. I think that's such a great question that I don't know if I would have ever thought of that, the difference between, doing this, texting, or dictating it, or is it possibly autocorrect? Who knows? It'll be interesting to see if they can even tell some of that. All right, let's get to our next question. This one's for you, Mina. Derek Wolf from YouTube. Pertaining to the standing objection that the defense carried throughout this witness's testimony, how exactly would this affect the proceedings for an appeal? Actually, Mina, I'm going to switch that over to Terry. That's more of a legal question. So Terry, pertaining to the standing objection that Moretti's not an expert, these messages haven't been authenticated, they shouldn't be coming in through him, how would this affect an appeal? Would that be an appealable issue?
Actually, that's an excellent question. And yes, it is an appealable issue. One of the standing objections that Stuart Adelson has said today, and he has said it earlier when Moretti was on the stand, is this is not an expert on this issue. He is not the caller. He is not the receiver, and he is not trained. He is not an expert. He's only extracted this information and tried to analyze it, but he doesn't have any background that he needs to have on that Cell Hawk and Cell Bright. Yes, he was trained, but he doesn't have enough expertise to talk about it in the way he's talking about it. So that's a standing objection, and I definitely think if the case doesn't go the way the defense wants it to go, that will definitely be a grounds for appeal. And I heard Adelson say it again this morning to make sure that that record was clear.
And he brought this up, that it could be reversible error the other day, I think, or a week ago or so. Block Boy Beats, Mina, I'm going to send this one to you. Do you think the jury is curious about why they, the defense, said it wasn't Melly's phone and now it's been proven to be his phone?
I think the jury is curious and they're confused as well. I find it interesting that the defense went from this isn't his phone to he doesn't speak that way. So the defense has kind of, I guess, adjusted to what's going on with the trial. But I think the prosecution did an excellent job of proving, hey, this is his phone. Here's these 4,000 million quadrillion text messages. Here's a whole bunch of pictures and videos to prove, yes, this is his phone. So in proving that this is his phone, I think the defense made an excellent pivot there and said, okay, well, this may be his phone, but he doesn't speak that way. So they further introduced that reasonable doubt needed now that it kind of, in my opinion, has been established that this may have been his phone. If he was sharing it, he did use it for a large majority of the time. And I think the cross was excellent in identifying, okay, maybe he does use it, you know, the majority of the time, but in this particular instance, it doesn't seem like he sent this this text message, because it's not how he speaks in these other text messages that he sent in the days leading up to this.
Our next question, Linda, I'm going to send over to you. Brittany James from Facebook asks, why is the judge allowing him, Detective Moretti, to keep saying his last name wrong? He was the lead detective. He should know how to say it, exclamation point.
Well, you know, that's something we just touched upon. And, you know, in the opening statements, the defense attorney who made the opening actually mispronounced his name, too. He called him Demons a lot. When we were like, whoa, I thought it was Demons. And people were saying, well, other people were calling him Demon. But, yes, I thought that was I thought the detective actually did it purposely. I really thought that's how he views him. He views him as a demon. And I'm a juror. Remember, I don't have any axe to grind. I don't care. When the detective did that, I told you earlier, it caught my attention and even tweeted about it. And the prosecution immediately said, no, let's talk about it. His name is, Jamell Demond, okay? And then pivoted on that. So I was taken by that, just like the viewer. And sometimes it's little things, trials come down to little things that could inject reasonable doubt.
It's funny, the first day of the trial, I'll just let you guys know, everybody, all of us were like, wait, how do we say his name? Is it Demons? Is it Demons? Is it Demons? I mean, we were all kind of like wondering. And then it seems like everybody settled on Demons. So now we have the pronunciation. Our next question will go to you, Terry. Camille Hale from YouTube asks, if Melly didn't text, quote, I did that, THAT, then who did? Why aren't the defense, or why isn't the defense putting more effort into who had possession of the phone when it was sent?
Well, what the defense is trying to do here is to say, look, it could have been anybody. We don't know who it was, and they don't have to answer that question. That's really a question that the prosecution has to answer. There were 8 people who got into those 2 vehicles that evening. Any one of those 8 people could have done it. They've already stated that Cortland Henry has lied to the police, so perhaps they want the jury to think that maybe he sent that text. But it's not up for the defense to prove who did or who did not send that text. It's really up for the prosecution to say, look, it was in Melly's hand. He sent the text. This is an admission. And so he did it. And that's what I want you to believe, jury. So right now, I think it's still quite unclear who actually sent the text. We may have established, I agree with Nina, that that phone was a phone that might have been registered and Melly's name or in his mother's name. But I think we've also established that there were many people in that house and they shared the phone and anybody could have been using it. So that point has not been proven at this part. And I don't think that the defense is going to try to prove at any point in time who actually sent that text, just to raise that doubt.
Mina, TJ's New Life from YouTube asks, Melly says he got out of the Jeep and into the red Mitsubishi, but Travion Glass said he didn't. That must carry weight.
Well, Travion Glass's testimony is somewhat, I would say, questionable, only in the sense of he doesn't recall the night properly. I believe there was a point where he stated during his initial interview that he got into the back of the vehicle, and then the video showed that he actually got into the front or something like that. He didn't even remember where he got into the car. So, and he was in that red car that went to Melly's house. So Travion Glass did a lot for, I think, both the prosecution and defense. But to me, he did come across as a little unclear as to what actually happened, because he couldn't even recall where he got into the car correctly. And he did also say that he was sleeping throughout the car ride. So for me, as someone witnessing the trial, just like everyone else, it placed some doubts on a lot of the things that Travion did say.
Mm-hmm. Linda, this next one's for you, at JustBrit910 from Twitter. Can the prosecution stop in the middle of the trial and offer Melly a plea agreement with a lesser charge if they felt like they were losing? At this point, I feel like they haven't proved it beyond a reasonable doubt. So I'm wondering what you think of that, Linda. I know the answer, but we'll send it over to you.
They can stop it or not stop the trial, but they can go to the defense at any time and ask if they're willing to take a deal, a plea bargain, to admit to whatever crime, then maybe take death off the table or put a certain amount of years, or to have him testify if they think he's not the shooter. The problem is they have really committed to the death penalty here, to him being the shooter. So the likelihood of them doing that is probably not very good, unless they were going to say, admit to the shooting and we'll take death off the table, and then we'd have to see what the defense would do.
Mm-hmm. Tone Loke, ACG, Mina asks from YouTube, where did Melly go after making Cortland bring their friends to the hospital? Was he hiding evidence, changing bloody clothes? Where was he?
We don't know. And that's really the problem. I don't think the prosecution has done a great job of really identifying where he was. They have coordinates and cell phone data, and they're saying, well, he could have been in this area. But one of the people that were on the stand very specifically said cell phone data tracks cell phones, not people. So we don't know where he went. We do know, based off Travion Glass's testimony, that he was seen at Frito Bang's house, but that wasn't exactly after the murder. In fact, we don't even know the time that he was at Frito's house, because Travion Glass was so, I guess, he was very reluctant to point down a time that everything happened. So we don't know where he went. All we do know is that he did end up at Frito Bang's house. According to Travion Glass's testimony, he had shorts on, and that's about all we know. And I don't think that's enough.
Well, we also have the text message from the phone texting Frito Bang to pick him up. And,
right.
I guess it was Miramar Parkway. There was an address on there. So we know that much at least. All right, we're going to take a quick break. Keep those questions coming to us on YouTube, Twitter, Facebook, Instagram, and Threads, and TikTok. We'll get to them when we get back. I'm Anjanette Levy. You're watching Law and Crime.
I disagree. It was some good questions. They had some good questions during the little lunch break. the text to, speech to text question. That was a great question. I just think that if I was a juror, something the defense picking that to go on, like they never said, like I still can't get over the fact they didn't. What did he mean by I did that? It didn't. That doesn't say I committed a. Like they didn't question that. They questioned the word that. They didn't question, what did that mean? Whether he spelled it D-A-T or T-H-A-T. They didn't question that. They just questioned the spelling of the word that. I thought that was kind of weird. I think the prosecution is going, now that they see which angle the defense is cross-examining Detective Moretti, I think that they're going to come back and kind of clean up some of those areas that the defense tried to point out. They got plenty of time now to go back and look through some messages and see if in fact maybe he did say that somewhere else, or I really just don't think that has much importance on how he spelled it. Oh, he didn't spell it this way all these times. I'm quite sure there's plenty of text messages where I spell words a certain way. Like sometimes I spell boy, B-O-I. But I'm sure you'll find in my phone where I've spelled boy, B-O-Y instead of B-O-I. It doesn't mean somebody else used my phone. So I still don't think it explains how he ended up at Fredo Bang's house, and Cortland Henry ended up at the hospital with the two victims. Like, that's wild. However, we're going to see how it play out. Defense still has their opportunity to present their case, and the state has an opportunity to cross-examine their witnesses. Now, calling of the witnesses is always going to be key, because from my understanding that the state's first few witnesses may be civilian. So, with that being the case, are they going to get on the stand and, buckle under the cross-examination? I know how to handle the cross-examination. Again, these are all things I see playing out here in the next few days. Make sure y'all hit that thumbs up for me.
We run the city, we run the team.
Welcome back. I'm Jeanette Levy, and we are taking your questions on the lunch break here in the YNW Melly double murder trial. He, of course, faces the possibility of the death penalty if convicted of the October 2018 murders of his two friends, YNW Juvie and YNW Sack Chaser. We're taking your questions with a great panel, so let's get right to them. We have plenty of them coming in. Ashley M. from YouTube, Terry, asks, do you think that it would make a difference if the jury never finds out who sent the "I did that" message?
Well, I do think it will make a difference if they can determine who sent that message. Now, listen, so far we've heard that message. It's been out of context. We're not really 100% sure what he was responding to. There's a message before that from Prezi Gambino saying, "Are you okay?" And then the next thing we hear is the response is, "I did that, shh." But if the jury can pinpoint that, I think that that would be a win for the prosecution. So far, though, we are trying to establish here from the defense, at least the defense is trying to establish here, that it wasn't sent from Melly because that's not how he spelled the word that. That's the first time the word has been spelled T-H-A-T. There are other 19 pages of Melly doing texts, and those texts were spelled D-A-T. So they're trying to put some doubt in that jury's mind that that text was sent. And, you know, to answer the question directly, if they can say for a fact who sent it, I think it will help the prosecution.
Linda, I'm throwing this next one to you. It's something we talked about earlier in the show. Handle from YouTube asks, Instagram doesn't autocorrect. So would that possibility of autocorrect be ruled out?
Oh, well, very good. You know, this is really interesting because we have a viewer, Handle, who is, you know, a lay expert, right? I mean, who uses Instagram and says there's no autocorrect. Thank you. Gosh. Sometimes when I have to type and things get auto-corrected, it's a disaster. But that's very interesting because the jury then is going to use their knowledge of social media. You know, we all have it on our phone to say, well, that then had to be typed. No one brought anyone in to say that it was dictated, you know, under, you know, because you had the accessibility functions turned on. And therefore, whoever said it meant to say that, not that. Now, what's the easy answer? Bring the real person behind the name of PZ Gambino in to say, hey, who are you texting? Who did you think you were texting with? Because maybe he didn't even know who he was texting with, because it could have been anyone on the other side. And what was your intention? Were you talking about the shooting?
It'll be interesting to see if the defense calls him to the stand. That would be a really, really interesting thing to see. They said they're calling some civilians, but I'm going to take a peek at their list and see if he's on there. I don't know if he is or not. This next question is going to go to you, Nina. Sorry, I lost my little spot here. At Biori909 from Twitter, why is all these text messages so important in this trial? Does it reveal who was behind the gun?
So I think we were all feeling that it was too much at one point. Like, what do all these text messages have to do with the actual trial? And I think the reason why is because they wanted to really hammer that point that this is Melly's phone. Here he is communicating with his girlfriend, with his mother, with Zach. So I think that's why we saw so many text messages. They really wanted to hammer that home. And what was the second part of the question, Anjanette?
Oh, let's get back up there and see. I'm sorry, I scroll through all these to find the good ones, and they're all good, but you know, the ones that I think we can all answer. Let's see, I think it got crossed out really quickly. Oh yeah, does it reveal who was behind the gun? Thank you, Christina, the producer, saved me right there.
It does not reveal who was behind the gun. And we were waiting for that smoking gun, you know, that smoking text message that somehow reveals Melly's participation in this crime, this alleged crime. I think their you know, aha moment was this, I did that-ish text message, and the defense just shredded that with the point that Melly doesn't speak that way. And he hasn't throughout the trial in these text messages.
All right, our next question comes from TikTok, and I will answer it. It's from India from TikTok. Is this the last day of the trial? Very quickly, no. We'll start the defense case tomorrow morning. This is not the last day. All right, and another one, Wandy Dillion from Instagram. How long is this trial? Seems like forever. It's going to go probably another week or two. So there's that question answered. Terry, let's get to you on this one. Question, why does this is from Justin Britt 910. What does everyone think about the text message, I did that, I think his account was hacked, or someone else sent that because of the spelling of the word that? So I guess I'll do a round robin on this one. Terry, just briefly, what do you think? Is the defense making some inroads with that?
I think they made some inroads, Anjanette. I think they're trying to say anyone could have sent that. It's not the way that Melly normally speaks. We know for a fact that many people use that phone. So I think they've made some inroads, and I don't think the prosecution has proven beyond a reasonable doubt that that was Melly who sent it.
Linda, is this much ado about nothing, or is the dat versus that?
Well, I think
is it that big of a deal?
I think it's a good deal, but it also doesn't necessarily say it's a confession, which is what the prosecution opened with in the big aha at the end of their opening, that this was a confession, especially in light of the text that we mentioned before with Trevion Glass, which said he would never do anything like that, which was specifically talking about the shooting. We don't even know what this text is really talking about.
All right, Mina, quickly, your opinion.
There's no context to the text, right? If this is an admission of guilt, I want to see the admission of guilt. There's no context. The leading question is not, did you do that? Or, or wow, did you got away with that? It wasn't that. It was, are you okay? And in the text messages with his mother, actually, he said that he had to go to the hospital and that he didn't want to. So this just raises more questions in my mind.
All righty. Chris Carney from YouTube asks, has the defense released their witness list for when they start their case? The answer to that is yes. And there are both expert witnesses on that list and lay witnesses. That means normal people like all of us. So there will be some civilian type witnesses who take the stand as well. But it'll be interesting to see which witnesses they start their case with. Let's get to this question. Linda, this is a really good one for you, and it's about a legal question. Let me get that one pulled up. Actually, I think I lost it. I'm so sorry. Carrie Trinan from YouTube, do you think the defense team is doing enough in their cross-examination? Do you think it would matter to get an expert on their side? I think they proved them wrong alone.
Is that for me, Anjanette?
Yes, that's for you, Linda.
Well, that's always the hard thing that you have is do you put a case on, or do you rest and say, look, we think that we have a not guilty verdict based on the fact the state has not proven their case beyond a reasonable doubt. And I will tell you that every single defense team struggles with that at the end of the case, even if they had planned to put on a case. Now, as I said in the past, I'm always a big one to put on a case, especially if you have to counter an expert. I think the defense needs an expert to counter an expert, no matter how many inroads you make, if you can find somebody who's credible, who's telling the truth, and who the jury will believe. So I would put on a case to confirm what they were saying in their cross-examination, that the cross wasn't just, pulling things out of the air and flying by the seat of their pants and all. I think that's very important. But they will have that discussion, and it'll be a very important discussion. And we may find that they decide to just rest, that the state hasn't proven their burden.
That would be interesting. We don't see that often, though.
Yeah, you do not see it because now the lay of the land these days is defense understands that you need more than just to rely on a burden with regard to a case. That if you're going to say, I didn't do that, okay, or that, or whatever here, that you really need to support how you have been putting on your case and cross-examining your case with experts that will say the same thing, and maybe some independent witnesses. I mean, it'd be interesting to see if the person whose name is PZ Gambino is called by the defense or not. But there are dangers in calling lay witnesses in a case like this, because you never know what people are going to say.
I'm going to send this next question over to you, Mina. Catherine Warner from YouTube. A lot of the photos shown of Melly were taken by other people, so surely that would prove that his group of friends have all had his phone at some point in time.
Absolutely. This is definitely a community phone, and not just his phone. At one point, he's texting his mother, and then it goes from his mom to his girlfriend, because the way that he's speaking to what seems like the same person, right? Because it's the same number, it changes. And then we later learned this is his girlfriend. So it seems like they're all living in the same house. They're all sharing the same things, sharing cars, sharing, phones. They're just all together in this YNW collective, and not even just the members of the group, but the people that are, next to them, like mothers and fathers. They're all a family here. So there's a lot of exchange and a lot of sharing, and that is a problem for the prosecution.
Alrighty, we're going to take a quick break so we can get to more of your questions, so stay with us. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. We're taking your questions during this lunch hour in the YNW Melly double murder trial. Keep them coming in on Instagram, TikTok, Threads, Twitter, Facebook, and YouTube. We'll get to as many of them as we can. This is a good one for you, Terry Austin, coming out to you. The Moosey Show from YouTube asks, was there any gunpowder residue on Melly? And were there any prints or DNA on the slug that was found inside the vehicle? Great question.
No and no. There was no gunpowder residue on Melly at all whatsoever, and you better believe that that is something the defense is going to be pushing home during that closing argument. And also DNA, nothing in the car except there was DNA on the back rear handle on the outside where Melly supposedly was sitting. Nothing else in that car had Melly's DNA on it. So those are two strong points as far as the defense is concerned. And the DNA they did find on that door handle wasn't found until very recently. And in fact, the authorities Moretti went back to actually get that DNA because the first time he could not find any of Melly's DNA in that car. So that too is a point that I guarantee will be pushed at the closing argument by the defense.
Linda, this next one is coming for you or to you. Brittany James from Facebook asks, have you ever seen a death penalty case that actually won for the state with no direct evidence?
Well, yes, you do, and we've covered some of them that have been circumstantial cases that have not been direct evidence, and many times circumstantial cases, believe it or not, can be stronger than direct evidence because you could have direct evidence, for instance, is, I saw you, Anjanette, pull that trigger. But we know that eyewitness testimony can be flawed, and as a matter of fact, is significantly flawed. So a lot of times, if your cell phone puts you in a location, if you have a motive to kill somebody, if you're found with gunshot residue on you, if you owned a gun with the bullet that matched the bullet that's in the person that died, but no one saw you, that could be very strong evidence for a conviction, even in a death penalty case. So yes, I have seen them. We've seen them here on the network. Whether or not this case qualifies, I don't know.
And I want to point out, too, that in jury instructions, juries are often told they're supposed to give the same weight to direct evidence and circumstantial evidence, or decide, which one, they decide what weight to give each piece of evidence. Each juror does, obviously, but they're supposed to look at them equally or weigh them equally. And, the eyewitness testimony stuff can get pretty dicey. Let's get to this next question. Sahara Ussery from Facebook, Mina, why does the lead detective persist in mispronouncing Demons' name and saying demons?
I think we're all wondering that. Like, sir, get his name together. Get it right. But as Linda mentioned earlier, it might be subconsciously to send a message. I believe a lot of what's been going on is Melly's being characterized as this certain person, a bad person. He's in a gang. He has a gun. Look at how he talks to his mom, But I think that subconsciously might be his way of really characterizing Melly. And I think it even speaks to him possibly being biased. The defense from day one has said, you guys really did not really do a thorough investigation here because you from the beginning said it was Melly without letting the evidence point to Melly. So, and I think in the cross, defense attorney Adelstein made that very clear. You had all these other people involved, a whole nother car, 4 other people that might have explained what happened, and you didn't speak to them immediately. You didn't search Melly's house, especially when Cortland Henry shows up at the hospital with what looks like a change of clothes. Cortland Henry lives at the house as well. So I think all of that is really pertinent to this case. And I actually think that it just goes to show that he might be a little biased because he's an intelligent man, clearly. It's not hard for him to get Melly's name correct.
All right, we're going to get to one more question. Candace Anderson from YouTube asks Terry, why didn't they question Melly the day after the murder and after he turned himself in February? Where is his interrogation tape?
Well, I mean, that's an excellent question. I think the person that they really should have been interrogating were, as Nina just said, everyone in that car, in both of those cars, all 8 people. We don't have any video of Melly being interviewed at all. He does turn himself in, and I think the defense has done a good job at saying to Detective Moretti on the stand, look, didn't he turn himself in February voluntarily? And the answer to that is yes. So I think at that point, since he had been arrested, since there was no reason for him to give a statement without his lawyer at any point in time, I think that they just decided, look, at least as far as the defense is concerned, we're going to say what we're going to say when we're going to say it during the trial or not. And he wasn't interviewed. I think it does show that there are a lot of people that were missed during that entire investigative process.
Actually, we do have time for another quick question, Linda. We've got about a minute, 30 seconds left. Jeremy J. from YouTube, wouldn't the IG message asking if Melly is okay in regard to the shooting be enough context for his response of, I did that?
Not really, because are you okay means, I'm okay. Not that I answer I did that. So I don't think there is any context for that, especially, given this whole case, and I'm going to go back to one point maybe for motive. If you're going to have context for all this, it's not just in terms of these text messages or the one to Trevion Glass where he says he didn't do that because it would create a war. But what is the motive? And the one thing they were lacking for context of text messages or whatever we're going to talk about, whatever the evidence is, the prosecution has never advanced it. They don't have to legally, but in a death penalty case, and in this case, I'd certainly like to know why he killed his two best friends.
Very interesting. I think they're going to say in closing it was money, but maybe we'll just have to wait and see. We don't really know at this point where exactly they're going with this, other than they said he did it. And they don't have to prove motive, and maybe they'll say that in their closing statement to the jury. We are going to wrap up this hour, but we have more of our YNW Melly Q&A to come. So please keep those questions coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok. We will get to them when we come back. We're going to let Terry Austin go so she can grab a bite before getting back into court. Stay with us. We'll be right back. Welcome back. I'm Anjanette Levy, and thanks for being with us here on Law and Crime during the lunch hour in the YNW Melly double murder trial. We are taking your questions as we always do during the lunch hour. So keep them coming to us on social media, YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we will get to as many of them as we can. YNW Melly, whose legal name is Jamell Demons, faces 2 counts of first-degree murder in the October 2018 shooting deaths of his 2 good friends, Chris Thomas Jr., who was known by Juvie, and Anthony Williams, who went by the nickname Sack. He faces the possibility of the death penalty if convicted under a new lower threshold signed into law in Florida by Governor Ron DeSantis back in April. Bortlen, who is Cortland Henry, that's his legal name, also faces first-degree murder charges and is accused of aiding and abetting and being an accomplice and an accessory after the fact to YNW Melly. He goes to trial in October. With me to take your questions is Linda Kenny-Bodden. She's still with us this hour. And also Offie Patterson, an attorney out in California. So ladies, let's get right to the questions. We have a lot of great ones coming in. Street Shark OG from YouTube asks, if the defense is able to discredit the state's evidence and witness testimony to a significant degree, what are the chances of a mistrial, Linda?
Well, if they're able to discredit the state's evidence, then there's a possibility there will be a not guilty verdict. I don't think the defense at this point wants a mistrial. As you recall, there was a point in the trial that the judge was seriously considering one, and the judge specifically said to the defense, make sure you want it, because sometimes us attorneys, we make the motion for mistrial to protect the record in case we're wrong. But we think we have the jury on our side, so we make the motion, but we do not want it granted. What we do want is a not guilty verdict, or if indeed there is a problem in that jury room, they can't agree, then we'll take the hung jury, which will then be called a mistrial, but not a mistrial to dismiss the jury, and it would then go to another case another time.
Our next question comes from Lake and Dees, and this one's for you, Offie, from YouTube. Did they offer Melly a plea deal, and should he take it after hearing the "shh, I did that" Instagram message?
Well, great question. I don't know if he was offered a plea deal, and I don't think the public knows whether he was offered a deal or not. Usually, if the prosecution is not certain of their case, they may offer a plea deal if it's more expedient to offer a deal to the defendant. That's another reason that they may offer a deal. I do think it was interesting that the prosecution ended their questioning of Detective Moretti with that statement, and then the way the defense crossed him, I think the defense counsel's point of contention was that, T-H-A-T, the way it was spelled in the text, versus dat, D-A-T, or the way he's answered or spelled the word dat in all of his prior texts in, I think that's the 9807 phone that the prosecution wants us to believe is Melly's. I think the only problem with that is now the jury is going to believe that the I did that is an admission or a confession to the crime by Melly, and I think that may be problematic for the defense.
Let's get to this next question. I think this is a good one for you, Linda. Random Gamery SD asks, why didn't Melly go with Bortlen to the hospital? Where are their satchels that they had that night? Why did Melly change clothes along with Cortland? Why was there no blood on the driver's side back seat? So we've got a lot of questions in there. This is a 4-for-1, Linda. The first part, why didn't Cortland go to the hospital, and where are the satchels?
All right, so let's answer that. First of all, let's put this in context that the prosecution has to prove what's in the satchels. They didn't do any search warrants. They didn't get any evidence. So we don't know what was in the satchels. There was an all-day session. The prosecution wants you to think that there were guns in the satchels, but they can't prove it. Maybe there were apples in the satchels. Maybe there was water. Who the heck knows what was in the satchels? Why didn't YNW Melly go to the hospital? Well, we don't know. Maybe the car was being shot up. Maybe he had already left the car before it was being shot up. Maybe he heard that somebody was then after him and he went into hiding and all. Changing clothes. Well, was it innocent changing clothes, or was it changing clothes because of blood? We do know that Cortland Henry had a change of clothes. But maybe YNW, when he's seen the next day, day and he's in the shorts, he took off the clothes and was wearing the gym shorts underneath that many people do. So why? But those are the questions the prosecution has to answer, not the defense. But I agree with you. A lot of questions out there, including why would YNW Melly want to kill his best friends, and that's not been addressed.
I have a lot of questions for Detective Moretti. He said he did 40 search warrants during this investigation earlier today. I know they did one on his manager's house, Track, because there was some statement, it's not in evidence, but there was a statement about him possibly hiding the gun. But, you know, we haven't heard that there was one done on Melly's house. And they knew that day, the day of the homicides, from looking at the surveillance footage, that there was a fourth person in the vehicle. So I have a lot of questions as well. This question is for you, Afi, known as BD from YouTube. If Melly was guilty, would Bortland get accessory to murder?
I do believe that whether he's guilty or not, Bortland is being charged as an accessory to murder, and I think he's also being charged with first-degree murder. I'm not certain of all of the charges, but that is, to my knowledge, what I do believe.
It's first-degree murder and accessory for Bortland.
And accessories, yeah. So whether he's found guilty or not, it doesn't matter. Those charges are just separate and independent, excuse me. And as we know, their trials have been severed. I do want to mention something about, however, the search warrant. I think the detective said there was no nexus that he could find between the murder and getting a search warrant for Melly's house. And that is so odd to me because it kind of went unchallenged by the defense counsel. The Detective Moretti said that's not how things work. I think, well, hey, that's not how things work for you, because if all of these gentlemen were living in one house and two of them were murdered, why would you not get a search warrant for the house? Maybe the satchels were there. Who knows?
Maybe they still are.
I do find that interesting because I'm just thinking, as right before you said it, Afi, I thought to myself, it's the home of two of the murder victims. You're telling me you couldn't get a search warrant for their house? I mean, I know they have to do the nexus and the probable cause, they have to do the affidavit, but seems like maybe they would have been able to get that. I don't know. I'm not a cop. So our next question comes from Latasha Gaffney from YouTube. Linda, one of the shots into the car showed movement of the car. Could that one shot suggest that they were moving at some point while being shot at?
Yes, and that's the problem with this, and I think that's where the defense is going to go with their expert. They're going to say the prosecution showed you all these pictures, but they were all stationary, right? But that if there's movement in the car, if there's movement of the car, the way the shots happen, what if somebody's head is outside the window, you know, and all looking, you know, looking this way? What if somebody had moved over to go away from shots they think are coming on the other way? Then maybe that gun that's going to be 3 inches to 4 feet away, it's the gun, you know, remember the edge of the gun, not the arm. No one has to be right next to you. So I think there's a lot of questions with regard to movement of the car, movement of the people in the car, and I think the defense will call an expert, I believe, to talk about where the reconstruction of the prosecution went wrong.
Anaya Thompson from YouTube asks, Afi, why won't they just pull evidence that he doesn't text the same all the time? For example, there was a time he used A, C instead of B when texting, and the defense pointed that out. So that's a good point in relation to the I did that versus I did that Instagram message. Do you expect the state to pull some stuff out and on rebuttal or a redirect showing that sometimes he didn't use the dat?
I would hope, if I'm looking at it from a defense counsel's perspective, that they actually went through every text message. According to counsel, they had thousands of pages of messages. I would hope that they went through all of the messages and they were able to confirm that he used that every single time, because the only thing the prosecution has to do is bring up one time that he used that he spelled it correctly. Or they can bring in another example of another word where sometimes he would use it casually, and in another instance, he would use the formal spelling of the word. So I would hope that the defense already prepared and that the prosecution won't be able to do that. But if they do, they would be spot on. They take the break, go through the messages and find it, and then present it on redirect.
Mm-hmm. Let's get to our next question. Cadence Marie from Facebook. I still don't understand if Melly did it, Linda. Wouldn't there be some kind of DNA in the car, just on the door handle he used to get in the car? What's going on with all this phone stuff? Where's the actual evidence against him? So Cadence doesn't feel that the phone evidence is compelling.
Well, let's talk about the DNA. You have DNA on the outside of the car handle. We saw Melly kind of touch the outside of the car handle. But yes, I mean, the fact that they found no DNA at all from him in the car. Did he get out of the car early? Did he not, was he wearing, some type of, I don't know what, because we saw what he was wearing. And that sounds either they're incompetent, that there was and they couldn't find it, or the DNA really wasn't there with regard to it. And with regard to the phones, yes, there is an issue, because remember, the FBI came in and said you can't tell certain things. You can tell certain areas, and indeed, phones sometimes bounce off different cell towers and different location of a cell tower, which would indicate maybe your phone wasn't at that location. But then the prosecution comes in and they present Moretti, who says, well, I can tell whether it was a phone inside or outside based on my review of the downloads of the phone. But the FBI couldn't do it. So I do think that when they get in that jury room, whoever wants conviction, whoever wants not guilty, are going to have both sides to argue. And I think that's a problem when you're talking about a death penalty case.
Kendrick Addison from YouTube, Offie asks, the prosecution has yet to put the gun in Melly's hand. What does Melly's defense have to prove to free him?
Well, they don't have to put the gun in his hand. They can just give you bits and bits and bits of circumstantial evidence to make it more likely that he did have the gun and he did pull the trigger, because we don't even have a gun. The defense does not have to prove anything. We all know the burden is on the prosecution. The defense needs to rebut a few things that the prosecution has presented, but the defense, it's not their burden to prove that he didn't have the gun in his hand. I think the defense does need to formulate somehow a likely scenario of what may have happened, because again, we know that Melly was there that night. He was in the car. 4 people got in the car and left. Only 2 people returned alive. So I think the defense needs to show us some type of plausible explanation or explanations. And from what I saw today, defense counsel gave Detective Moretti, I only saw suspect 1, suspect 2, suspect 3. He went down the line. I don't know if he's going to present any more, but I think, that's a way that the defense is definitely offering alternatives to what may have happened.
Mm-hmm. Yulizwa Parmar from YouTube asks Linda, why couldn't they force Melly to give them, the police, his bag that he had that night? We're back to the satchels. We understand at that time they were not sure what happened that night, but the clip shows that Melly had a bag.
Right, Melly had a bag, somebody else, Bartlett had a bag. A lot of people, I think there were 2 bags, 2 satchels. You cannot force somebody to say, turn over the bag you were carrying. That would be incriminating himself, which he, if indeed under the Constitution, which you can't do. What they could have done is got a search warrant for it, the state, if they felt the bag held evidence, which they did not do. So they didn't get a search warrant for it. They didn't say the bag held evidence. They didn't go before a judge. And then they can't say, well, then, Melly, you must have to produce that bag, because if you don't produce it, you are guilty here under the law, and we're going to use your non-failure to produce it against you. And that the judge's not going to allow that.
It'll be interesting to hear on redirect if they actually did that. I mean, Moretti said they did 40 search warrants, but that's my question. It's like, where's the warrant for the bag? All right, let's take a quick break, and I'm out of here for now, at least. We've appreciated and enjoyed taking your questions as always, and we'll be back doing it again tomorrow. Linda's going to take over after this break, and we'll see you another time. I'm Anjanette Levy, and you're watching Law and Crime. The Melly trial is going to resume very soon. Stay with us. We'll be right back.
State Attorneys. The witness, Mr. Patrick Martin, already remains on stand. The jury is adjourned. Counsel, are you ready to proceed?
Yes, sir.
How about the state?
Yes, sir. So we're printing up our copy of jury instructions for Mr. Howard at his request.
Just a minute. Still utilizing them.
No.
Pardon? You're still in the restroom. Perfect. Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, Mr. Dennis, his counsel, the assistant state attorneys, as well as the ladies and gentlemen, the juries. Our witness remains on the stand. I hope you all had a nice lunch when we broke. Counsel was on his cross-examination of Detective Moretti. So hopefully you're able to continue now. Counsel, is that right?
Yes, sir. Thank you.
You may.
Detective, I think I left asking you if you ever asked Jameson Francois how long you had the 9807 phone that's attributed to Melly.
I never asked him that question.
You never asked him?
Correct, sir.
So you don't know specifically from him. Well, let me back up. When you met him, he pulled it out of his pocket, correct?
It was in like a fanny pack.
Okay, he pulled it out of his fanny pack. And you never asked him how long he had it, correct?
Correct.
I'm going to make him, because he had the 9807 phone, the 3 holsters in his storage locker, and the ammunition found in his house as a suspect.
Okay,
that would be number 6.
Number 6. The Mr. Jameson Francois, the cell site data does not put him at the scene.
I'm not asking. There's no question pending, so I appreciate you offering.
Okay.
So we get the 9807 phone from Mr. Francois. And as we sit here today, you don't know where the 3 guns are that were found and that were missing from the holsters in his storage, correct?
Correct.
And you don't know anything about the gun locks, whether or not they are related to additional guns, correct?
Correct.
Now we know that when Cortland Henry was arrested, he was wearing different clothes or a different shirt than what was portrayed by him as he walked out of the studio, correct?
He was arrested on the 26th.
I'm sorry?
You're right.
I said he wasn't arrested on the 26th.
Oh, you're absolutely right. We know that when you saw Mr. Henry at the hospital and compared what he was wearing at the hospital to what he was wearing as he walked out of the studio, he had on a different clothes.
Yes.
We also know that the victim's DNA was on Mr. Henry's shirt, correct?
Yes, sir.
We also know that Mr. Henry had GSR located on his hands.
2 parts GSR.
Now, when Melly surrendered in February of 19, I think it was February 13th.
Yes, sir.
For all practical purposes, I think you marked case closed.
Oh my God!
Yes, sir.
When did Sergeant Williams from BSO get involved, if you know?
The exact date I do not know.
Would it, it was after you closed the case, correct?
Yes, sir.
Do you know who asked Sergeant Williams to get involved, and he's the one who supposedly did the trajectory analysis?
That actually transpired when the case was filed with the state attorney's office. So sometime late January 2019, and it's also been corroborated by the fact that when they turned over discovery to you, it said trajectory analysis pending. So that information was made available to you back then. We just had not started that portion.
Would it surprise you to learn that it was November 16th of 2021 that Williams was contacted by the prosecutor's office?
No.
That was some, what, 3-4 years after this event?
Yes, sir.
Would it also, you met with Sergeant Williams, correct?
Yes, sir.
And would it surprise you to learn that after meeting with you and looking at your reports, he put that aside?
I don't know, sir.
Would it also surprise you to learn that he came into this courtroom and said, do you know when Detective Polo from the BSO got involved in this investigation?
It was sometime before we went back to grand jury and re-indicted.
Would it surprise you to learn that he didn't get involved until February of 2022?
That would surprise me.
That was what? Close to 4 years after the event.
If you say so.
Well, 18 to 22, isn't that about 4 years?
I'm just not arguing with you, sir. I'm just arguing with you.
Would it also surprise you that after this young man surrendered and was charged with these murders, that years later there was a DNA analysis again done?
Yes, sir.
You're aware of that?
Yes, sir.
Heck of an investigation, I guess.
Excuse me, Councilman.
I'm sorry. I apologize. Would it also surprise you that after the Jeep was searched and processed hours on 3 different occasions, that miraculously Sergeant Williams found additional evidence in the vehicle that obviously someone missed?
Yes, sir, I read that.
So someone did do their job completely.
Objection, Your Honor.
Stay.
We have so far 6 suspects in this case. Cortland Henry, correct?
Yes, sir.
David Hedgepath,
Yes, sir.
a guy Bentley unknown because you didn't bother to look at that,
Objection, Your Honor.
correct?
You meant to.
Sustain.
Bentley, correct?
We did look into it. We could not identify it.
Okay. Unidentified. Christopher Thomas Sr., correct?
Yes, sir.
The incident at Walmart,
Yes, sir.
Jameson Francois so far as suspects.
Yes, sir.
You also talk about a Montrell Rowe as a potential suspect, correct?
I never identified Montreal Rule as a suspect.
Well, Did you review some jail calls without telling me what they are? I don't want to get in trouble. Without telling me what they are, did it lead to Montrell Roll knowing some information?
I have to be careful, I don't want to upset anyone and cause a sidebar. There was a conversation.
It just requires a yes or no. Sir.
Okay. Repeat your question, sir.
Did Montrell Roll, because of information he may have known, become at one time a suspect?
No.
No. Did you interview Montrell Roll or his sister?
His sister, yes.
And without telling me why or what was said, that was because of some information, whatever that information was, dealing with these murders, correct?
Correct.
Now, there was talk, I think by you, at the request of the state, about a Jay Green.
Yes, sir.
Okay. Jay Green was someone who had, based upon your investigation, threatened this young man, correct?
And there was some tension between the two, yes.
Did you bother to interview Jay Green?
I did not because...
It only requires a yes or no, sir.
Okay.
So
No,
the
sir.
answer to your question is, and you keep writing those notes down,
Okay.
you did not even take the time to interview Jay Green, correct?
Correct, sir.
That's suspect number 8. There was also an individual by the name of Frito Bang that you mentioned.
Yes, sir.
Frito Bang, his real name is Frederick Gibbons, correct?
Correct.
Frederick Gibbons was a rap singer, correct?
Yes, sir.
He lived right around the corner on the other side of the lake where Melly lived, correct?
Correct.
There was also some talk on the various phones you analyzed of putting this young man on the plate, right?
Yes, sir.
That is a fancy way or a code way of saying, I'm going to kill him, correct?
Correct.
And that was done by, let me make sure, that was done by Herc
Yes, sir.
and Goon.
I don't remember Guna, but I do remember her.
Did you take the time to interview Herc?
No, sir.
So that would be suspect number.
Objection, Your Honor, to the use of just sidebar.
Like, I'm just saying objection, just.
Yes, sir.
You refer
I'm
to
trying.
no argument.
Yes, sir. That would be suspect number 10.
Yes, sir.
There was mention about Goon, who was on various messages, also threatening this young man because he wasn't responding to Herc or any of the other upper echelon people in this gang called the Bloods.
Okay.
Correct?
Correct.
Did you talk to Goon?
No, sir.
Do you even know Goon's real name?
No, sir.
Do you know Kurt's real name?
No, sir.
And I think you mentioned a guy by the name of Gino that also was, you reviewed some messages saying he's not responding to the various members of
The United Blood Nation?
Yeah.
Yes, sir.
Tell the members of the jury who Gino is.
Probably another gang member.
Do you know his real name?
No, sir.
We're now up to 13 suspects.
Yes, sir.
And I don't like to stop at 13 because some people think that's an unlucky number. So how about Kwando Wando, who also threatened this young man? Did you bother to talk to him or investigate him?
No, sir.
We'll stop at lucky 14. I think that's 13. Now, as a trained investigator, you would never intimidate any witness to a crime, would you?
Correct.
You would never threaten a witness if he said something you didn't like, would you?
No, sir.
You mentioned the name of Patrick Deloche.
Yes, sir.
And you mentioned that you interviewed him as a potential witness, right?
Yes, in the presence of the state attorney.
Okay. And did you threaten him by...
I'm sorry?
Objection, hearsay.
Sustained.
Didn't you threaten Patrick Deloche
Objection.
without telling me what it is?
Overruled.
No, sir, I don't believe I threatened him. Did I advise him that lying to us could result in him being charged with a crime?
Patrick
Yes.
Deloche. You mentioned an Adrian Davis.
Yes.
Did you threaten him at all?
No, sir.
If someone would ask for an attorney as you're questioning them, you would...
Speculation.
Sustained.
You interviewed Adara Scott, correct?
Yes.
Did you threaten her?
Did not threaten her, sir. I advised her that not being truthful and honest could result in her being arrested for accessory after the fact.
And go to prison for a long time, correct?
objection.
Hearsay.
What he said, my understanding is.
Yes.
I'm not asking what the person might have said, what you said, Detective.
Yes. I had to review the statement, but I did advise her that lying to us could result in her being charged for accessory after the fact.
And go to jail for a long time, correct?
If that's what's in my statement, and that's what's in my statement.
And didn't you also tell Patrick Deloach?
Objection. Hearsay.
It's what he said. I'm sorry.
Sure.
Let's go to Patrick Deloach and see if I can refresh your recollection. May I approach?
Yes, sir. What are you approaching with?
A statement. And his words.
Whose statement?
Patrick Deloach with Detective Moretti and Christine Bradley present.
Thank you.
That conversation was not specific to the murder. That was specific.
Did you, in fact, threaten to have him be federally indicted? Yes or no?
Yes, because of gun sales.
Gun sales. Did you, in fact, tell him that he would not see his kids for a couple of years?
Possibly.
Well, may I approach?
Yes, sir. Same document?
Yes, sir.
Yeah.
Yes.
Yes, sir.
Did you, in fact, threaten Jameson Francois?
Same answer, sir. We advised him that lying to us could result in their arrest.
Did you, in fact, tell him he would be deported to Haiti?
Yes.
Did you, in fact, tell him that despite the fact that he has lived in this country since he's been 5 years old, he would be deported. That these are his words.
Counsel?
I'm sorry.
Relevance.
I apologize.
Hitting witnesses.
Restate your question, Counsel.
Did you, as a trained investigator, threaten Jameson Francois to be deported to Haiti, even though he's been in this country since 5 years?
Yes, sir.
Did you, in fact, threaten that he would not get fed and get any medicine in the Haitian jails?
I don't know about that in conversations.
Threatening a witness is...
Objection, Your Honor.
If anyone asks a question. What's the objection?
Relevance.
Thank you. Overrule this relevance. Go ahead. Ask your question.
Do you think threatening a witness who tells you something that you don't like really gets to the truth?
Objection, Your Honor. Relevance.
Sustain.
When you questioned Jameson Francois, were you alone, or did you bring immigration officers with you?
We were at the Chrome Detention Center, so of course the immigration officer had to be there.
May I approach?
Same state.
A different state. Jameson Francois. Did you, in fact, tell him that the jails are overcrowded, in referring to Haiti? It's disease-ridden. It's a, excuse my French, a shithole.
Thank you. Objection noted. Overruled.
I underlined it so you could see it.
Excuse me, Counsel.
Oh. All right.
Judge, you're still a witness there.
Yes, sir.
Your Honor.
Sustain. Counsel, I've asked you a couple times.
I apologize. Have you ever heard the term a key to an interview to get to the truth is you catch more with honey rather than vinegar?
Yes, sir.
Would you consider these threats that you gave to these various witnesses?
Objection, Your Honor. Speculation. Relevance.
Sustain.
You obviously don't follow that technique.
Objection, Your Honor.
Sustain.
Let me show you the list of suspects that we talked about and see if this is true and correct. May I approach?
Sure, Counsel.
Is this a fair and accurate list of the suspects we talked about that you indicated are suspects in this case?
Yes, sir.
Would you sign it for me? And date it today's date? get the document back? I would ask that this be marked as the next offense exhibit.
You're going to say rejected this time.
It can be marked as a exhibit for identification. It's marked for identification. It's not evidence.
And does that document exhibit C, defendant C, fairly and accurately?
No, sir.
It doesn't. It lists all the names we talked about, correct?
Yes, sir.
All the names involved in this case, correct?
Yes, sir.
I move it in evidence.
You're going to say so okay.
Sustained.
I have no further questions.
Madam, is there any redirect to this witness?
Yes, please. So, Detective Murray, you said that's not a fair and accurate statement of all of the suspects. Who needs to be added to that list before you could say it actually describes the people that are suspects in this case?
It's missing the defendant's name.
And who would that be?
Jamell.
Okay. With regards to the first thing counsel asked you about, the word that. I want to go to what's been previously put into evidence as State 64. And if this somebody so kind as to switch to the other source. Gary was kind enough to get our screen working. Going to what's highlighted on the screen. What's the name of the song by Mr. Demmons? What is that one called? In the bottom right-hand corner of the screen?
Melly fix that THAT_01.mp3.
Okay. In terms of going through the various messages. Yes, please. Going with previously in evidence is States 106. Is that same song sent back and forth between Mr. Williams and Mr. Demmons?
Yes, ma'am.
That was from States 106 for counsel. Going to States 112. Statements, and this is the conversation between the 6942 number on September 16th of 2018. How does the defendant spell that?
THAT.
Okay. On November 18th of 2018, how does the defendant spell that?
THAT.
On December 31st of 2018, how does the defendant spell that?
THAT.
Counsel asked you about that red Mitsubishi. I'm going now to states 118, the Facebook.
Gotcha, bitch.
Specifically page 293. Starting on page 294, the conversation, who on October 28th of 2018, who is that being sent by? Who is the author of that message, hey baby?
Gianna Thompson.
On October 30th of 2018, 21:24:13 UTC. There's a what does this message from Ms. Thompson to Jamell Demon's Facebook say?
You gave me a truck, baby? Question mark, question mark.
Do you know what truck that is?
The red Mitsubishi.
Before that, October 28th, 2018. What does Jamell Demon send as a message to Janet Thompson?
My lawyer and my label told me not to talk to nobody.
Excuse me, I have an objection. May we approach?
Yep.
I don't know, y'all. It's not looking good. That's horrible. That's horrible from the defense. Like, you make a point to point out that he doesn't spell that THAT, and then they pull out. Like, I thought it was a dumb line of questioning from the beginning, and now I think it's even dumber.
Okay, continuing on, told me not to talk to nobody.
But I'm taking care of the funeral, and your family is going to be good for life. But I know it won't replace this heartbreak ever, but it's the least I can do. Then 4 emojis that we don't have there.
On October 28, 2018, how does Janet Thompson respond? You can just read the first through ashes.
I don't want him buried. I want his ashes.
So, Detective Maroney, counsel asked you about that list of suspects.
Yes, ma'am.
On Bentley. I'm going to go to in States 70, page 132. And this is in the chat with Choppa on August 27th, 2018. Is the name Bentley referred to there?
Yes, ma'am.
And if you could say, and I just want you to read from here to here.
Bentley told him not to sell it. Not to sale.
So you talked about a charm or something. Is this the post regarding this necklace from Walmart?
Yes, ma'am.
And what is the date on that?
8/25/2018.
So is Bentley and the person from Walmart the same suspect?
No, ma'am.
Okay. What information do you have in this case that puts Montrell Rule at the scene?
No information whatsoever. He was in jail at the time.
So his alibi checked out.
Yes, ma'am.
So we can cross him off that list. Let's go to Chris Thomas Sr. Any information whatsoever that puts him at the scene?
No, ma'am.
Any indication whatsoever that he wanted to kill his own son?
No, ma'am. No.
Cross him off the list. Going to David Hedgepeth, Crucial Almighty. You indicated you first wrote a search warrant for his involvement on October 31st of 2018.
Yes, ma'am.
Anything that ties him to the scene in your mind?
None whatsoever.
And in terms of the follow-up investigation with his work records,
Yes, ma'am.
after you reviewed them, did you move on in your investigation?
Yes, ma'am.
Going now to Portland Henry. Is Mr. Henry involved in this case?
Mr. Henry is a co-indicted defendant.
Going now in terms of the Jameson Francois. Does Mr. Francois have an alibi?
Yes.
How so?
He was at his house at the time.
And how do you know that?
His wife.
How else do you know that?
Cell site data.
What about Jay Green? Counsel wouldn't let you answer the because, so I'm going to ask if you complete your answer. So why can you say because Jay Green?
Because later that day, the defendant reached out to Jay Green, had a conversation with him on Instagram, and the conversation was, "I love you, fool."
Okay. Continuing on to Frederick Givens. How do you know that he wasn't there at Pembroke Road and US 27?
Based upon the text conversation, he is the one that went to the scene, or to the pickup point, to pick up the defendant and take him back to his house.
Okay. And in terms of the location of the defendant going back to his house, whose house do you mean?
Frederick Givens' house.
Frederick Givens' house. Does Mr. Demon's phone connect back to the YNW Castle?
That day, no.
Kirk, Goon, and Gina. Do you have any indication whatsoever that either of those individuals were here in the state of Florida on October 26th of 2018?
No, ma'am.
Quando Rondo. Who is that?
I don't know, ma'am.
And in terms of when you're interviewing a witness, do you advise them of what perjury is?
Yes, ma'am.
Is that done in every single one of your statements?
Yes, ma'am.
In terms, there's a lot of talk about surveillance footage and going and looking at various surveillance footage on that. Does the business have an obligation to cover the roadway in front of it?
Most of the time they don't.
Why?
It's not in their interest. They're most places like CVS and Walmart, they're more focused on what's going on inside.
So in terms of all the various places that you went to, did you collect evidence if it didn't show anything?
No, ma'am.
In terms of the cellular analysis that you did,
Yes, ma'am.
were you able to compare and contrast the cellular analysis you did with the one that the FBI did?
Yes, ma'am.
Were there any discrepancies between the two?
Objection.
What's the objection?
Conclusion on it and speaking for another witness.
Overruled.
Were there any discrepancies between those two?
No, ma'am. My report mirrored their report.
Nothing further, Your Honor.
I have just a few with the court's permission.
Yes.
Would you agree with me that if you don't check the surveillance tapes, you have no idea what's on them?
Correct.
So you don't know what's on any of these cameras on all of these companies that had cameras up and down Miramar Parkway, Pines, and the route that you took the helicopter ride on. Correct?
We were able to walk it out and assess what the cameras covered and what it did not cover.
Frederick Givens, you said purportedly my client went there. Certainly you got a search warrant to search that house for blood, clothes, or anything of that nature.
Sustain.
Did you get a search warrant for?
Excuse me, I sustain the objection.
You mentioned Frederick Givens, is that correct?
Yes, sir.
You mentioned and just told this jury that supposedly my client went to that house immediately after this incident, correct?
Yes, sir.
Did you get a search warrant for that house? Verify or collect evidence?
Outside the scope.
Over.
We did not find out the exact location of Frederick Givens until we actually seized the cell phone, analyzed the cell phone. Because if you look back at previous statements, no one could ever give us the address. So by the time we actually discovered what his address was, he was no longer living in that area.
So the answer is no.
Correct.
Would you agree with the premise that you won't find any evidence
Objection, Your Honor.
Sustain.
if you don't?
Objection, Your Honor.
Excuse me. If. Sustain. Rephrase the question.
The individual, may I do it from here? I'm sorry, Judge.
Yes, sir.
The individuals that you say had no connection to this incident,
Yes.
you did not investigate, correct?
Incorrect.
Did you investigate Wanda Quanda?
Don't know who that is.
Did you investigate Jay Green?
Yes.
Did you investigate Bentley?
Couldn't determine who Bentley was.
Can I see that list?
Uh-oh.
Did you investigate Walmart incident?
No, sir.
Did you mention Montrell Road?
Yes, sir.
Did you investigate his sister?
Yes.
Did you investigate her?
No.
Did you investigate Goon?
No.
Did you investigate Gina?
No.
Thank you.
Any further questions, counsel?
Briefly, Your Honor. Detective Moretti, do you look at any one piece of evidence by itself?
No, ma'am. Our decision to make an arrest is based upon the totality of the circumstances. It's all the factors encompassed in the case, not just one person's name, one text message. It's everything.
Nothing further, Your Honor.
Thank you. Is this witness excused?
Yes, Your Honor.
Thank you, sir. You may step down. You're excused.
Thank you, Your Honor.
Madam, you want to call your next witness?
At this time, state your breath.
Ladies and gentlemen, I need a few minutes with the attorneys. Do not discuss the case. Don't form any opinions about the case. Don't allow anyone to discuss the case in the presence. Certainly no research. If you look heads on your chairs. Thank you.
Let's hear how the little experts is gonna try to spin this. They gonna get in here and watch. They gonna be like, well, no.
Reflecting jury step down. Counsel remain along with the defendant. So stay rested. Are we still on schedule for tomorrow? Then you said Brendan Collins is going to be your witness. Is that right?
Yes, Judge.
Yes.
The possibility, Judge. Possibility.
And he's available, Ms. Bradley?
Yes, Your Honor, he indicated, last council had asked for him to be here at 8:30. He said he could be here at 8:30.
All right. So, assuming that you call Mr. Collins, is there any other witnesses that you anticipate calling tomorrow now?
We may have one more witness.
All right, so, and is the state going to have any rebuttal?
If they, depending on if they call the one civilian, there is a possibility of that.
So it's a possibility, and it's going to be long or short?
Very short, Your Honor.
So, are you all telling me or suggesting to me that you think you'll be over by, let's say, lunchtime tomorrow?
Yes, Your Honor.
Mr. Adelstein?
Yes, sir.
Yes? No.
Yes.
So, I know you asked me to just adjourn or let the jury go now, so nothing's changed in that regard, correct? I'm just going to excuse the jury, tell them to be back here tomorrow at 9?
Yes, sir.
Yes, Your Honor.
All right, and any objection if I just have Gary tell him, see you back tomorrow at 9?
No.
No, you.
All right, so Gary, can you tell him, excuse him, walk him out?
Absolutely.
Thank you. So, you have any motions?
Yes, Your Honor. We move for a judgment of acquittal on the premise that the state has not presented a case sufficient for a jury to rely upon and for a conclusion of guilt beyond a reasonable doubt. Beyond the several suspects who were not investigated, with the contention is they have no connection to the case, which would be a difficult contention to make, having not investigated them. The DNA evidence is inconclusive. The cell tower evidence, the witness said when it's specific, it's not accurate, and when it's accurate, it's not specific, and gave us essentially a statement that in certain instances, he was really able just to say that 2 phones were in the city of Miramar. And so they have no, this is a circumstantial case, and the circumstances themselves lend to a multitude of various scenarios. And in that instance where a set of circumstances can lead to the conclusion of guilt and conclude to the conclusion of innocence, a jury would be required, and therefore we would argue that such a level of proof doesn't rise to the level of proof beyond reasonable doubt. What it does is it invites the jury to speculate and find proof less than proof beyond a reasonable doubt, where other scenarios of innocence exist. And so we would respectfully move the court for a judgment of acquittal at this time.
State?
Your Honor, the state would also make sure that counsel is aware of Bush v. State 295, 7th, 3rd, 179. That's a 2020 Florida Supreme Court case in which there is no special circumstantial standard of review on the judgment of acquittal. The state has put forth competent evidence to support each and every element of first-degree premeditated murder as to both count 1 and count 2, that the defendant is the individual who committed said crimes, that the victims are the ones that were deceased, and that there is a premeditated killing.
I'm sorry. We also renew all of our previously made objections during the motions to suppress before Judge Siegel, and all of our objections that we made during the course of the trial and the motions for mistrial.
Thank you. All right, so I'll defer ruling, take it under advisement unless there's some other response. Is that yours? No other response?
That's it, Your Honor.
So I'll defer ruling, take it under advisement. So the plan going forward now is we're going to hear from, or may hear from Brendan Collins tomorrow. You may have one additional witness other than that, correct, Mr. Adelstein?
Correct.
And the state may or may not have one rebuttal witness, but if that's the case, it'll still be done by, let's say, noon tomorrow, right?
I think that's a fair assessment.
Okay. So then tomorrow afternoon, you're going to read the jury instructions tonight.
Yes, sir.
and we're going to go over, we'll have a charge conference tomorrow afternoon. We're anticipating then doing closings. I'm just going to tell the jury, you're going to find out tomorrow morning whether you're going to be available Wednesday morning or not.
Yes, sir.
So if you're available Wednesday, we're going to do closings on Wednesday. If you're not available Wednesday, I'll just tell the jury to come back on Thursday. Is that what we all agreed to? Yes?
Yes, sir.
Yes, sir.
All right.
I would prefer to be here, Your Honor. I understand there are higher authorities compelling my presence elsewhere, but that is my preference, would be here and be closing on Wednesday.
And my preference is to be home, Judge, to be candid.
Understood, but you suggested that there's some motion filed or something like that where they're saying they're not ready in the other case.
Correct.
So I don't know anything about it. Respectfully, it's just, Judge Fine requested your presence a couple of weeks ago because he had 250 jurors coming in, doesn't want to waste their time. All right, so I acquiesced to it. But in any event, so we'll just play it by ear, and we'll see everybody back tomorrow, 9 a.m., and we'll sort it out then. All right?
Yes, sir.
Thank you. And what's up? Assuming goes to the jury on the earliest it'll go is at assuming your closing's Thursday. So it should be Thursday, it goes to the jury, and they'll have the room sequestered for then. Unless something happens and you're basically available on Wednesday, then we'll do it on Wednesday, and the jury will get sequestered Wednesday night.
Yes, sir.
All right? All right. Play it by ear. Thank you.
Thank you, Your Honor.
Karen?
So it's looking like Thursday. This is going to get to the jury, y'all. It's looking like Thursday. We're going to get some jury action. You know what I'm saying?
Oh, yeah!
We ready for it. So that means the defense is going to put. So this is what they they betting on, that the state didn't have enough already to sway the jury towards a guilty verdict. That's what they betting on, because it sounds like they only have a few witnesses that they're going to bring forth in their portion of the case. So that's what it's looking like. Because if they finish him, the state been on for almost a month, or at least a couple to 3 weeks, and they only gonna have 2 days. I don't know. That's wild. Seemed like it would take like a whole day just to refute like the ballistics. Cause I mean, you got the ballistics. You also have the you also had a medical examiner. So I was under the impression they were gonna bring in experts on both of those. I guess I'm wrong. I guess I was wrong. Well, let me know what y'all think in the comments. We gonna listen to the Law and Crime little legal team and see what they talking about, how they think it went. My favorite portion of the afternoon session was the THAT versus DAT, because before they went to lunch break, there was a lot to be made of the fact that he never spells that THAT. And I was thinking from the jump, oh yeah, they got all the lunch. Somebody gonna go find where he spelled that THAT and not DAT. And that's exactly what happened. That's exactly what happened. soon as she got her chance, she dug into that. The suspect list, she sat in front of the jury and crossed out everybody that they had on the suspect list one by one until it left her with one person, or two in this case, Cortland Henry and Jamell Demons, a.k.a. YNW Melly. It's the comments, yo. I've been reading some of these comments and be like, YNW, you not winning. Like, it's crazy. One of the questions is, I'm trying to figure out how they gonna get him out the car. How they gonna show that he was out the car when it happened? I don't even think they gonna. I mean, it seemed like they gonna take the stance that, it wasn't him, so he don't know. He don't know this. He don't know that. He can't answer this because he doesn't know who was busting at him. But closing arguments is gonna be they gonna paint the whole picture. They gonna start with the girlfriend mama, who the regular people, she got paid. She got paid. How you forget your original statement to police, and then all of a sudden you willing to go to jail and lose your job and everything to not come testify? They're going to start right there. And then they're going to walk it down. They're going to walk it down from there. The other key part was the defense tried to say, oh, you didn't get a search warrant for Frito Bang's house? Well, we didn't have the address. By the time we got the address, he had moved. So that's logical. It seems logical. Because, of course, they would want to get a search warrant for his house. Why wouldn't they? That's where the clothes got changed, possibly. Because his own friend testified that he did not have the same clothes on at Frito Bang's house that he had on when they left the studio. My dog out of control, y'all. So I don't know. We're going to sit and wait for a few and see what they say when they come back. But it's looking like that's the end of the actual court session today. So we'll see what's going on. Make sure y'all hit that subscription. Hit that thumbs up for your boy.
We run the city. We run the team.
Out of objection, the chair is authorized to declare a recess at any time. We welcome everyone to today's hearing on oversight of the Federal Trade Commission. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank the gentleman. We begin today's hearing with, as we normally do, with opening statements, and then we'll get right to our witness. And we appreciate Ms. Kahn being with us, Chair Kahn being with us today. At a speech in Berlin in 2022, Chair Kahn told an audience that the challenges facing antitrust today were,
that's
quote,
what they did,
the result of a choice made 40 years ago.
They just went ahead and ended the whole thing. I'm not watching this. What the hell? All right, so we'll be back tomorrow, man. I appreciate y'all tapping in. Appreciate the love. Make sure y'all share it to somebody, man. Share it to your Facebook, your Instagram. Let some other people know about the channel so we can keep it growing. Shout out to my moderators. Y'all know the slogan, one love and no love. Nobody told you they love you, man. We love you over here. One love family. And till tomorrow morning, I'm out.
Run the city.